Good afternoon. Welcome to Webb County Court at Law 2. I'm Victor Villarreal, judge of your Webb County Court at Law 2. This is the civil and probate docket for Wednesday, August 5th, 2026. The time is now 2:05. Court is now in session. Assisting us today are Cecil Rodriguez, court administrator and interpreter and court recorder. Ms. Cynthia Flores is the court coordinator. Video conference co-hosts this afternoon include Mr. Lopez, Ms. Ramos, Ms. Cuellar, and Mr. Hernandez and Ms. Rivera. These proceedings are being electronically recorded. Everyone is instructed not to record any portion of these proceedings. Only a court reporter may provide the official record. As with all proceedings, violation of these instructions are subject to contempt hearings. If you're joining us online, you're instructed to act as though you were in court because you are in court. The rule here is simple. If you would not do it in person, don't do it online. For example, do not operate a motor vehicle. There is no smoking, no chewing gum, wear appropriate clothing, and always exercise proper courtroom decorum. The court will now call the cases in the order of readiness. Ms. Rodriguez.
First on is Counsel Frank Barrera, page 8, number 21.
This is 3W NAFTA Solutions, Inc. versus RTS Financial Services, Inc., cause number 2026 CVD 5602. Court marks Mr. Barrera present by video conference. Good afternoon, Mr. Barrera.
Good afternoon, Judge.
Is there any person here on behalf of 3W NAFTA Solutions, Inc.? Court marks no persons present in person, no persons present by video conference. Mr. Barrera, this is a docket control conference. What is the announcement?
Judge, we were recently retained on this matter. We just filed a notice of appearance with the court. We're planning, this is an appeal from a small claims court, so it'll be a trial de novo. We're planning on filing a motion to dismiss and motion to enforce based on a contract that the parties had that had the form selection clause. And we'll be filing that in the coming days. I mean, probably by the end of this week, Judge.
So I can then set that for, I will set that on a final pretrial hearing date. How much far in advance do you want that date?
The sooner the better, Judge. We could have that filed by Friday. So,
Ms. Noriega, give us a final pretrial hearing date in about 45 days and then give us a bench trial date about 30 days thereafter.
My next available, Your Honor, would be October 6th at 2 p.m.
It's a final pretrial hearing, and then the bench trial, if those attempts are unsuccessful, will be held on
November 12th at 2 p.m.
Any objections to those dates, Mr. Barrera?
no, Judge.
We need an earlier date, file a request, and we'll see if we can push it onto a docket. Any other dates, excuse me, any other courts, any other cases for Mr. Barrera?
That's all I have, Judge. Thank you. May I be excused?
Yes, sir. It's good to see you. Have a great day.
Thank you, Judge. You too.
Page 4, number 10.
Kevin Madrigal Ramos Jr. versus Vanessa Montserrat Aguiana Rodriguez, cause number 2026 FLB 734C3. Kevin Ramos, Vanessa Rodriguez, if you're present, please step forward. Speak into the microphone and tell the court, are you Kevin Madrigal Ramos Jr.?
Magdiel. It's Magdiel.
It's Magdiel.
I apologize.
Right.
Is your name Kevin Magdiel Ramos Jr.?
Sí, señor.
Yes, sir.
Welcome to court. The court marks you present in person. Vanessa Rodriguez, are you present? Court takes notice that respondent is not present in person, not present by video conference, and the court takes notice that she was served with citation by posting on May 19th, 2026. Mr. Ramos, are you ready to go forward?
Sí, señor.
Yes, sir.
Before we do, Ms. Flores, does the court have Mr. Ramos's email address?
Yes, Your Honor.
Mr. Ramos, would you raise your right hand, please? Do you solemnly swear or affirm that the testimony you will give in this cause will be the truth, so help you God?
Sí, señor.
Yes, sir.
You may lower your hand. Mr. Ramos, now that you're under oath, Is your true and correct name Kevin Magdiel Ramos Jr.?
Sí, señor.
Yes, sir.
One more time, Mr. Ramos, you're joining us live and in person. Mr. Ramos, you filed this case on May the 6th, 2026. On that date, had you lived in Texas for 6 months?
Sí, señor.
Yes, sir.
Had you lived in Webb County for 90 days?
Sí, señor.
Yes, sir.
Are you currently married?
Sí, señor.
Yes, sir.
To whom?
Con Vanessa Montserrat Aguiñaga Rodríguez.
With Vanessa Montserrat Aguinaga Rodríguez.
What was the date of your marriage?
El 2 de abril del 2017.
April the 2nd of 2017.
And has your marriage become insupportable?
Sí.
Yes.
When did you stop living together as husband and wife?
El 22 de enero del 2022.
January the 22nd of 2022.
Is there any possibility that you reconcile?
No, señor.
No, sir.
Were there any children born in the marriage?
No, señor.
No, sir.
Were any adopted?
No, señor.
No, sir.
Do you know if your wife is expecting?
Sí, no, señor.
No, sir.
Is there any community property that the court needs to divide?
No, señor.
No, sir.
Is there anything else that you would like to tell the court, Mr. Ramos?
No, señor.
No, sir.
Mr. Ramos, in your case, cause number 2026 FLB 734C3, the court at this time finds that it has jurisdiction over this case, meaning this is the proper court form and venue to consider your divorce. The court finds that you entered into marriage with Vanessa Montserrat Aguiana Rodriguez on the 2nd day of April 2017, but you stopped living together as husband and wife on January 22nd, 2022. The court finds that your marriage has become insupportable due to a discord or a conflict of personalities that destroys the legitimate ends of the marriage relationship. The court finds that there are no children of the marriage, none were born, none were adopted, none are expected. The court finds that there is no community property to divide. Mr. Ramos, at this time, the court finds that there is no reasonable expectation of reconciliation, and the court hereby renders and pronounces you divorced. Give me a second to review your decree.
Gracias.
Thank you.
Mr. Ramos, the court has reviewed your decree. I have signed it, and I'm tendering the original signed decree to the clerk's office. Your divorce is final. Do you have any questions for the court, Mr. Ramos?
No, señor.
No, sir.
I wish you well, sir. Have a good day.
Page 926.
State of Texas versus Gerardo Solis, cause number 2022 CV354L2. Speaking to the microphone and tell the court your name, sir.
Gerardo Solis Jr.
Welcome to court, Mr. Solis. The court marks you present in person. Counsel, into the microphone your name, please.
Yes, Rene Benavides here for the state, Your Honor.
Welcome to court, Mr. Benavides. Court
Thank you.
marks you present in person. Counsel, what is the announcement?
Your Honor, we have an agreement where we're going to, we've offered deferred adjudication for 90 days for court costs, and he's agreed to accept.
Is there a written agreement or are you requesting a reset for the effectuation of that agreement?
We don't have a written agreement. It's the first time I meet with him.
All right. I see. But ostensibly, you're going to file something. I will sign off on it, and that would dispose of the case, right? There's
That-
no necessity for the court to come back and have a status on it.
That's correct, Your Honor. I think as long as Mr. Solis is aware of where to go to make arrangements for court costs within the 90-day period of that, we'll go ahead and file the proper document.
And remind the court how much time is the agreement to pay that?
It's a 90-day deferred.
All right, so give us the pro se setting, Ms. Flores, in December. Actually, no, give us that order's due date,
The orders due date for August or December, Your Honor?
December.
December, that. The orders due date will be December 14th at 12 noon by submission.
All right, so comply with your agreement and they will be either filing a dismissal of your case or they will file something to bring you back to court.
Okay.
Mr. Solis, do you have any questions for the court?
No.
Just for the purposes of the record, Mr. Solis, have you entered into this agreement freely and voluntarily?
Yes.
Court has heard yes. All right, Mr. Solis, I wish you well. Have a good day.
That's all the state has, if I may be
It's
excused.
good to see you, counsel.
Good to see you.
Have a
Judge.
good day.
Thank you.
Page 9, number 25.
In the matter of Blanca M. Wolf, cause number 2026 SME 19L2, Marcela Knight Bernardo Valdez III. Are any persons present? Speak into the microphone and tell the court, are you Bernardo Valdez?
Yes.
Welcome to court, Mr. Valdez. The court marks you present in person. Marcela Knight or any other person. Is any other person present on this case? Court finds no other persons are present in person or by video conference. Mr. Valdez, we were last here about a month ago and there was information missing on page 2 of the small estate affidavit and also on page 7. Court has reviewed that and that is now filled in fully and available for the court's consideration. Anything that you would like to tell the court, Mr. Valdez?
No.
All right. In this case, Mr. Valdez, cause number 2026 SME 19L2, the court, based on the contents of the affidavit, finds that it has jurisdiction. The court, having reviewed the affidavit, sees that this estate for Blanca Wolf actually does qualify for a small estates affidavit. The court, having taken notice and reviewed everything, the court is approving the request. The court has signed the order approving the small estate affidavit. The court is tendering the original order to the clerk's office, and that should be available as early as tomorrow. Mr. Valdez, do you have any questions for the court?
No, I don't.
I wish you very well, sir.
Thank you.
Have a good day.
You too.
Page number 11.
Lizeth Alejandra Ortiz Gonzalez versus Abraham Gonzalez, cause number 2026 FLB 79 scratch. 2026 FLB 769C3. Lizeth Gonzalez, Abraham Gonzalez, if you're present, please step forward. Speak into the microphone and tell the court, are you Lizeth Alejandra Ortiz Gonzalez?
Yes, sir.
Welcome to court, Ms. Gonzalez. The court marks you present in person. Speaking to the microphone, Mr. Gonzalez, and tell the court, are you Abraham Gonzalez?
Yes, sir.
Ms. Gonzalez, you filed this case. Are you ready to go forward?
Yes.
Are you ready to go forward, Mr. Gonzalez?
Yes.
All right. Ms. Gonzalez, Mr. Gonzalez, I'm going to ask that you both and each raise your right hands. Do each of you solemnly swear or affirm that the testimony you will give in this cause will be the truth, so help you God?
Yes.
Court has heard yes from both. You may lower your hands. I'm going to begin by asking you some questions, Ms. Gonzalez, because you're the person that filed this case. Now that you're under oath, is your true and correct name Lizeth Alejandra Ortiz Gonzalez?
Yes.
Court marks you present in person. Ms. Gonzalez, you filed this divorce on May the 12th, 2026. On that date, had you lived in Texas for 6 months?
Yes.
Had you lived in Webb County for 90 days?
Yes.
Are you currently married?
Yes.
To whom?
Abraham Gonzalez.
What was the date of your marriage?
August 3rd, 2024.
And when did you stop living together as husband and wife?
March. I don't remember what day, but it was 2026.
March of 2026. And has your marriage to Mr. Gonzalez become insupportable?
Emotionally and mentally insupportable. Yes.
Is there any possibility that you reconcile?
No.
Ms. Gonzalez, were there any children born in the marriage?
No.
Were any adopted?
No.
Are any expected?
No.
Is there any community property for the court to divide?
There's a property that we bought during our marriage. I have a land under my name. He has a mobile home under his name. However, it's not a combined title, so the land belongs to me and the mobile home belongs to him.
Did you purchase the land before or after August the 3rd, 2024?
No,
Before or after?
after.
And the mobile home, was that purchased before or after August 3rd, 2024?
After.
So both of these properties are community properties. Are you telling the court that you have an agreement with Mr. Gonzalez that the division of your community property would be that you keep the land and he keep the mobile home? Is that your agreement with Mr. Gonzalez?
That was the agreement.
Do you believe that this is a just and right a just and right division of your property?
I do.
Is there any other property that the court needs to divide?
No property.
Are you asking the court for a name change?
Yes.
To what name?
Lizeth Alejandra Ortiz.
Is there anything else that you would like to tell the court?
Yes, there's a loan that I took out to cover part of his debt. And I wanted him to be responsible for half of that.
What is the current amount owed on that debt?
I don't remember, but I have it with me. I don't know if I can pull it out.
If you would like to refer to something to refresh your memory, you may.
The current balance is 8,552 with 72 cents.
8,552 and
72 cents with an annual percentage rate of 14.85.
when was that loan taken out?
Mm,
Let me ask it this way. Was that loan taken out before or after August 3rd, 2024?
After.
And what was the principal amount at the time the loan was taken?
10,000
And what was that loan used for?
to cover his credit card debt.
And after that loan was taken out, was that amount actually used to pay Mr. Gonzalez's credit card debt?
$7,000 was used to pay for his debt.
After that happened, did Mr. Gonzalez have any credit card debt?
Yes.
So he still has some credit card debt as far as you know?
As far as I know, he continued to use his credit card.
Oh, I see. All right. Is there any other, and you think that adjustment right division is that you keep half and he keep half of that debt? Is that what you're telling the court?
If it's possible for him to cover the 7,000, that would be great. I think that's fair. But I leave that to you, Judge.
Is there any other property, and that could mean real estate or houses, retirement, business accounts, bank accounts, savings, anything else that vehicles that the court should divide?
No,
All right. You're under oath, Mr. Gonzalez. Is your true and correct name Abraham Gonzalez?
Yes, sir.
Mr. Gonzalez, you heard the testimony of Mrs. Gonzalez. Is there anything you disagree with?
I did pull out my 401k to get us the mobile home and the land. And instead of pulling out my 401k for that, I should have used my 401k to pay off my debt. But instead, I thought we could maybe work something out together and use that for that. But instead, I used it for us.
So I guess let me now take this one step at a time. How much did you pull out of your 401k?
I believe it was like 8,700.
And what amount of that did you use towards purchasing anything?
As far as down payment for the trailer, down payment for the land, and utilities, and whatever else needed to be covered, I covered that.
All right. Well, you heard Ms. Gonzalez tell the court that she believes that you have an agreement together that she would keep the land and you keep the mobile home. You also heard her testify that she believes that that is a just and right division. Do you believe that that is in fact a just and right division?
Well, I at first thought that was the plan, but I don't have the funds to take out the trailer. At first I did tell her she can keep everything, including what was inside. Instead, she denied everything. She took what she wanted, and she almost left the house almost empty, which is okay to me because I'm not a very materialistic person. But I told her to keep everything, and for her like to come back and fight me for it, like it's unfair. Then I told her she can keep everything again, and she didn't want it. She wanted the land. I wanted to remove the trailer, but I don't have the funds to remove the trailer. At this point, I'll leave it up to we then agreed to sell it, and she showed me a form to sign, and I misunderstood the form until I did further investigation, and it benefits me now. It benefits us both to sell both at the same time.
Mr. Gonzalez, what do you believe is the value of the land?
The land itself,
Yes, just the land.
as in the price,
Yes.
I believe right now it's at 43,000. And since she moved out, I took all of responsibility of all the utilities, the land. I took care of the land, as in far as cutting the grass and keeping it maintenance.
And what do you believe is the value of the mobile home?
I believe it's at 75,000 or 73.
All right. So make a specific request. What do you believe this court should do to do a just and right division of your property?
If we can come to the agreement to sell both together, and from here on to the end till it sells, for her to keep paying her property.
It sounds to me that Ms. Gonzalez hasn't agreed. So when that happens, I'm happy
Yeah.
to effectuate, to order any agreement that you have. But when you don't agree, this court needs to make a decision. So help me make a decision by telling me what you want, and then I'll ask Ms. Gonzalez what she prefers.
I thought we were coming in to agree on that, but I guess she has a different thought now.
So tell me what yours is.
To sell both together.
Mm.
Because like I mentioned, I don't have the funds to take out the trailer.
What do you believe the costs associated with taking it out are?
It's around $4,000 to $5,000.
All right.
If anything,
Miss
a little bit more.
And you've asked the court to sell it, which leads the court to believe that you don't have a use for it.
Well, I live there. I don't live there because I can't live there at all. It's very unemotional. It's emotional for me to be
Okay.
there.
I understand.
Yeah.
Ms. Gonzalez, respond to this request by Mr. Gonzalez. Do you agree or do you disagree with his request?
Your Honor, I disagree. I filed this 4 months ago and I kept telling him, I kept researching, doing my own research, going out of my way to see how we can come about this and come together and make a decision. And he kept refusing every time. When I went to the real estate company, I spoke to them and I had them call him so he can go sign the paper so we can combine the property and become one property in one title. And he declined. He refused, he refused, he refused. At some point, obviously, I got tired. And I think the best thing, I don't want to take any of his property. I understand that he says he took out his savings 401k. I agree that he should keep his mobile home. I don't want it. I want to keep my land. As of right now, I think it's fair that he's taking care of all the bills and everything since he has exclusivity of the home. I don't live there. I take care of my own bills. I don't think it's reasonable for me to be paying him when I don't live there. And he makes double the money that I do. I don't make enough to pay part of his bills when he's living there and my bills.
Ms. Gonzalez, you heard Mr. Gonzalez testify and tell the court that he believes that the value of the land is 43,000 and his belief is that the value of the mobile home is 75,000. Do you agree or do you disagree with those valuations?
I believe the land is valued at 46, if I'm not mistaken.
All right. Ms. Gonzalez, is there anything else you would like to tell the court?
No.
Mr. Gonzalez, is there anything else you would like to tell the court?
No, sir.
Ms. Gonzalez, Mr. Gonzalez, in your case, cause number 2026 FLB 769C3, the court at this time finds that it has jurisdiction over this case, meaning this is the proper court form and venue to consider your divorce. The court finds that you entered into marriage on August the 3rd, 2024, but you stopped living together as husband and wife on March of this year. 2026, the court finds that your marriage unfortunately has become insupportable due to a discord or a conflict of personalities that destroys the legitimate ends of the marriage relationship. The court finds that no children were born, adopted, or are expected of the marriage. Regarding the division of property, Ms. Gonzalez has requested that she keep the land that is community property and that Mr. Gonzalez keep the mobile home. I think based on what the court has heard here, that a just and right division would be that, but that Mr. Gonzalez, since he's getting a greater valuation, a greater equity in the community property, that he should be fully responsible for the rest of the loan. The court assumes and presumes that all loans taken out during the marriage are community property and that those funds were used to benefit the community itself, the marriage. So because you get something of higher value, you get the debt associated with the marriage. However, here's the caveat. The court is going to give Mr. Gonzalez 90 days until November the 20th, 2026, to figure out what it is you want to do with the mobile home, because the court heard that you live there, but you have a use for it. You sometimes live there, but sometimes don't. So you have those 30 days to either figure out if you want to place that mobile home somewhere else for you to live on, or you can sell it, keep the equity, and then liquidate all of the debt, right? So it's completely up to you. The court finds that this is a just and right division. Ms. Gonzalez, the court hereby changes your name to Lizeth Alejandra Ortiz. And at this time, Ms. Ortiz and Mr. Gonzalez, the court finds that there is no reasonable expectation of reconciliation, and the court hereby renders and pronounces you divorced. Give me a second as I modify your final decree of divorce. Before I do, Ms. Ortiz, do you have any questions for the court?
I do. I know you mentioned you're giving him 90 days. The land has to be paid every first. I believe that while he has his mobile home, that he should be liable for the monthly payments.
You own the land, you make the payments on the land, he owns a mobile home, he's responsible for all utilities on that mobile home until he gets out. Yeah.
Even if I don't live there on the land,
Yes, because it's yours.
but he
Absolutely.
has exclusivity of the land.
I've taken that into account. Yes, ma'am. Mr. Gonzalez, what is the address that the mobile home sits on?
It's 2629 Sabana Lane, which is Sabana.
Laredo, Texas, 780 40.
6.
Is that the correct address, Ms.
Yes, sir.
Ortiz? Thank you. Ms. Ortiz, Mr. Gonzalez, the court has made those modifications in your final decree of divorce. I have signed it, and I'm tendering the original to the clerk's office. Ms. Ortiz, do you have any questions for the court?
I don't.
Mr. Gonzalez, do you have any questions?
No, sir.
I wish you both very well.
Thank
Have a
you,
good day.
Court.
Page 6, number 16.
So in the matter of Rogelio Lujano, cause number 2026 FLF 979C3. Anybody present on that case, please step forward. Step as close to the microphone as possible and tell the court, are you Rogelio Lujano? Welcome to court, Mr. Lujano. The court marks you present in person. Speaking to the microphone and tell the court, are you Mariceli Vasquez?
Yes, sir.
Welcome to court, Ms. Vasquez. The court marks you present in person. Mr. Lujano, are you ready to go forward?
Yes, sir.
And Ms. Vasquez, are you ready to go forward?
Yes, sir.
All right, Ms. Vasquez, Mr. Lujano, I'm gonna ask that you both raise your right hands. Do each of you solemnly swear or affirm that the testimony you will give in this cause will be the truth, so help you God?
Yes, sir.
You may lower your hands. I'll begin with you, Mr. Lujano, because you're the petitioner, you're the person that brought this case to court. Is your true and correct name Rogelio Lujano?
Yes, sir.
Mr. Lujano, I've had the pleasure of reading your petition, but tell the court why you're here today and what is it you're asking?
I want to adopt my stepdaughter to be my daughter.
Tell the court some background. What is your relationship with and how is it with Ms. Vasquez?
Oh, she's a wonderful daughter, and was she said I'm just the dad, and I've been taking care of her for since she was 2 years old.
Now, I have to go through this next series of things so that you're fully aware and you understand. Normally in adoptions, I advise persons that come to court, and usually people think that at the age of 18, that their obligations with their kids that goes away. And that's never true because there's always a moral and civil obligation to your kids when they're 30, 40, 50 and beyond. And then I also do probate cases, which means that cases that people leave wills and they leave houses and bank accounts, they come back to court. And so I have to advise you that if the court grants this request, your obligations to Marceli, they don't end in this life, but your estate will have an obligation to her even in death.
Oh,
Do you understand this?
yes, sir.
And this is an obligation you're ready, willing, and able to undertake.
Yes, sir. 100%.
All right. Ms. Vasquez, is your true and correct name Mariceli Vasquez? Ms. Vasquez, tell the court what you think about this request.
I was actually the one that asked him. It was in Father's Day. He's always told me that he's my dad, and I've always called him my dad. I just wanted to make it official, have his last name.
All right. Just need to ask you one more question, Mr. Lojano. You filed this case June 26, 2026. On that date, had you lived in Texas for 6 months?
Yes, sir.
Had you lived in Webb County for 90 days?
Yes, sir.
Anything else you want to tell the court, Mr. Lujano?
Nothing, sir. Yeah, we're good.
Anything else that you want to tell the court, Ms. Vasquez?
No, sir.
Mr. Lujano, in your case, cause number 2026 FLF 979C3, the court finds that it has jurisdiction over this case. The court here just gets to do in the legal world what's been going on in the real world since you were 2, and that is that this court gets to decree you the father of Mariceli Vasquez, and the court hereby changes your name, Ms. Vasquez, to your requested name of Mariceli C. Lujano. Congratulations.
Thank you,
Thank
guys.
Give me a second as I fill out your decree. There's one question, Mariceli. I'm gonna sign this decree. There's one modification that I think that I should make. Your middle name right now is just listed as Z. Would you like just to leave it as a single letter, or do you want me to spell out some name?
It's just a Z.
All right. Congratulations to you and your family. I wish you all the best.
Thank you.
Judge.
Page 3, number 7.
Joseph William Stevenson versus Alexis Herrera, cause number 2026 FLA 834C3. Joseph Stevenson, Alexis Herrera, if you're present, please step forward.
I'm present.
Are you Alexis Herrera?
Yes, sir.
Welcome to court, Ms. Herrera. The court marks you present. You're participating by video conference. Are you Joseph, speak into the microphone and tell the court, are you Joseph William Stevenson?
Yes, sir.
Welcome to court, Mr. Stevenson. Let me just ask, was that the response audible? Welcome to court, Mr. Stevenson. The court marks you present in person. Ms. Flores, does the court have Ms. Herrera's email address?
No, Your Honor.
Ms. Herrera, what is your email address?
That's going to be Lexi Herrera 1995@gmail.com.
Just in case someone doesn't know how to spell it, spell out that email address.
LEXYHERRERA.
And then you said 1915
Correct.
at,
Gmail.com.
all right.
Your Honor, the reason that we called this case is because there has been an answer filed by Attorney Monahan.
Ms. Herrera, I see that Attorney Joseph Monahan has filed into this case. Is it your decision that Mr. Monahan represent you?
Yes, Judge.
All right. Mr. Stevenson, this is this attorney's first entry into the case. The court has a policy that each person is given one request for a reset because of no service, because of their first entry, or because this is an attorney's first appearance. And that's the case in this case. But before I grant that request, do you have an objection to the court granting more time so that this person can come to court?
Oh, no, sir.
Court has heard no, sir. All right, Ms. Flores, give us a trial on the merits date on a regular docket date, please.
Yes, Your Honor, September 3rd at 2 p.m.
Any objection to September the 3rd at 2 p.m., Mr. Stevenson?
No, sir.
The court has heard no, sir. Any objection, Ms. Herrera?
No.
All right, we'll see you here on September the 3rd at 2. I wish you both very well.
Thank you.
Have a good day.
Page 8, number 22.
Jose G. Ramirez Estrella versus Maria Ramos de la Berlanga, cause number 2026 CVD 61L2. Please step forward. Speak into the microphone and tell the court, are you Jose Ramirez Estrella?
Sí, soy yo.
One more time, are you Jose Ramirez Estrella?
Yes, sir.
Yes, sir.
Court marks you present in person. Please get as close to the microphone as possible and tell the court, are you Maria Ramos de Berlanga?
Sí, yes.
Welcome to court. The court marks you present in person. Mr. Estrella, you filed this lawsuit in the Justice of the Peace Court, and I think you got a decision that you disfavored and then filed this appeal. Is this correct?
Es correcto que usted interpuso esta apelación después de que no obtuvo una respuesta favorable del juez de precinto.
Sí, así es.
Yes, correct.
So this is a trial de novo. Are you ready to go forward today?
Sí.
Yes.
What was your cause of action? What is it you're suing Ms. Berlanga for?
¿Cuál fue su acción? ¿Por qué estuvo usted demandando a la señora Berlanga?
Porque yo le vendí una propiedad y tiene desde octubre del año pasado que no me ha dado ni un pago. Ella quedó de pagar las taxas y no las ha pagado.
Because I sold the property to Ms. Berlanga and she has
Ya quiere-
not paid me, and she hasn't paid the taxes either since last year in October.
So if we went forward today, what is it you're asking the court for?
Así que si procedemos el día de hoy, ¿qué es lo que está pidiendo al tribunal?
Que, que desaloje o que me pague todo el dinero cash.
For her to vacate or for her to pay all the amount in cash?
Ms. Berlanga,
Sí.
I think you received a favorable decision at the Justice of the Peace Court. Are you ready to go forward today?
Señora Berlanga, creo yo que usted recibió una respuesta favorable del el precinto de justicia. ¿Está lista para proceder el día de hoy? Sí. Yes.
Right, Ms. Noriega, does the court have Mr. Estrella's email address?
Yes, Your Honor.
Does the court have Ms. Berlanga's email address?
Yes, Your Honor.
All right. Mr. Estrella, do you have any documents that you would like to enter into evidence or for the court to review?
Señora Estrella, ¿tiene usted documentos con usted mismo que usted quiera que este tribunal revise o acepte ante evidencia?
Sí,
Yes.
Have those documents been uploaded to Case Center?
¿Esos documentos están en el centro de evidencia en línea del tribunal?
bueno, hicimos el papeleo con un notario, nada más.
Well, we only did the paperwork with a notary, that's all.
Let me ask it this way. Have you been given an opportunity to take whatever documents you want the court to consider and to upload them into the evidence sharing platform Case Center?
Déjeme hacerle esta pregunta. ¿Se le ha dado la oportunidad a usted de poner los documentos en el centro de evidencia del tribunal que es digital? ¿Usted ha digitalizado los documentos que está con usted mismo que usted quiere introducir como evidencia?
Ah, sí, tengo fotos.
Oh, yes,
¿Dónde?
I have pictures.
I'm gonna find that response to be no.
Que su respuesta ha sido no.
Ms. Berlanga, do you have any documents that you would like the court to receive or review?
Señora Berlanga, ¿usted desea que este tribunal vea algún documento el día de hoy como evidencia? Sí. Yes.
Have you been given an opportunity to upload those documents into Case Center?
¿Usted ha tenido la oportunidad de archivar esos documentos en el centro de evidencia digital del tribunal? No. No.
Okay, then I'm going to give you one more hearing date so that you have an opportunity to upload your documents into Case Center.
Les voy a dar una audiencia más para darle oportunidad a ambos a interponer esa evidencia en el centro digital del tribunal.
Ms. Flores, what is that docket date?
Your Honor, if I may, this is Ms. Noriega.
Yes.
That'll be September 2nd at 2 p.m. And if I may put something on the record, Your Honor,
You may.
the emails for both, I just received them this afternoon. So they do not have any access to case lines, but I will go ahead and send them an email with instructions on how to do that.
Su siguiente audiencia será el 2 de septiembre a las 2 de la tarde. Debido a que ustedes dos proporcionaron su correo electrónico esta misma tarde, ustedes no tienen acceso al centro de evidencia digital del tribunal. Se les dará acceso el día de hoy y se les mandará por correo electrónico las instrucciones de cómo archivar sus documentos.
So let me explain this to you. Any documents that you would like the court to receive and review, you would just scan them and upload them to that platform.
Para que sea más claro, cualquier documento que usted desee que este tribunal entre en evidencia durante su audiencia, necesita ser recibido por el centro digital de evidencia. Necesita usted escanearlos y subirlos a esa plataforma.
You can scan them or take pictures, but they must be uploaded at least 24 hours before your next hearing date.
Ustedes pueden escanearlos o usted los puede subir por medio de fotografía. Sin embargo, debe de hacerlo 24 horas antes de la siguiente audiencia.
This court for the last 6 or 7 years or so has not accepted paper.
Este tribunal por los últimos 6 o 7 años no ha recibido documentos.
One of the many benefits to this is that you will have access without being able to modify these documents of each other's uploads.
Uno de los beneficios de nuestro centro de evidencia digital es que cada uno de ustedes podrá ver los documentos de la otra persona sin poder ser modificados.
So the benefit is that you will have complete access to every single document that your opponent is going to try to use in court, and you will not be surprised.
Y el beneficio es que cada uno de ustedes tendrá acceso a la evidencia y cualquier documento que la contraparte vaya a tratar de introducir como evidencia y así no va a haber sorpresa el día de la audiencia final.
Mr. Ramirez, do you have any questions for the court?
No.
Señor Ramírez, ¿alguna pregunta para el tribunal? No.
Ms. Berlanga, do you have any questions for the court?
¿Alguna pregunta para el tribunal?
La documentación debe estar en inglés 100%.
Does the documentation need to be in English 100%?
The short answer is yes.
La respuesta corta es sí.
Una pregunta.
Yes.
La propiedad, como ya está avanzado el pago, la empecé la arreglé y gasté mucho en el arreglo de la traila. Y cuando estaba limpiándola, personas se acercaron a rentar. Para pagarle al señor, pues la renté. Entonces,
One question
Eso
in
te mo-
regards to the property, due to the advance payment that I had given and the amount of money that it took for me to fix the trailer, I was cleaning up the trailer and a few people went near the property. And in order for me to pay him, I rented it out.
Sí, desde mayo no han pagado, entonces, o sea, todo está en espera de lo que decida juez. La corte. Ellos no han pagado. Con lo que yo arreglé es con lo que le debo al señor. Parte
Since
de lo
May,
que le debo al señor.
they have not paid. And everything is at standstill here with the courts until there is a ruling. They have not paid. And
So-
everything that I paid is what I put into the property.
So I cannot give you a legal opinion as to what the possible outcomes or what should be happening in this situation.
Yo no le puedo dar una opinión legal o lo que va a suceder de manera legal en este caso o lo que usted necesita considerar.
But Mr. Ramirez, is this dispute covered by some contract?
Señor Ramírez,
Some-
¿esta disputa o alegación o está cubierta por algún tipo de contrato entre ambos?
Sí, hicimos un contrato con notario público.
Yes, there is a contract with the notary public.
So the best thing I can say is present your case and evidence, including that contract, on September the 2nd.
Lo mejor que les puedo decir es que están preparados para presentar su caso, su evidencia en esa audiencia.
Ostensibly, you two are the signatories to that contract, not other third persons that the court has no jurisdiction over.
Es altamente probable que las personas y las firmas en ese contrato son ustedes dos y no otra tercera parte.
Miss,
Falta una hija de ella, que es la que también estaba a nombre de ella.
We're missing one other person, her daughter.
understood.
Mi hija estaba en el hospital.
My daughter's in the hospital.
So she's welcome to participate in person or by video conference on September the 2nd at 2 p.m.
A ella se le da la bienvenida a estar aquí en persona por medio de videoconferencia. El día
Mr.
2 de septiembre.
Mr. Ramirez, Ms. Berlanga, I wish you both and Ms. Perez Ramos very well. Have a good day.
Les deseo a José y la joven Pérez Ramos lo mejor. Buen día.
Bueno.
Page 3, number 6.
Edith Garcia versus Julio Emanuel Gallardo, cause number 2026 FLA 819C3. Ms. Garcia, Mr. Gallardo, if you're present, please step forward. Are you Edith Garcia?
Yes.
Welcome to court, Ms. Garcia. The court marks you present in person. Julio Emanuel Gallardo, are you present? Court finds respondent not present in person, not present by video conference. Let me confirm with the clerk's office whether there is service on respondent.
There's no service, Your Honor.
Ms. Garcia, Mr. Gallardo has not been served, but you have a request for citation by publication. Tell the court what you know about the whereabouts of Julio Emanuel Gallardo.
Bueno, a lo que yo visité a su mamá me dijo que no se encontraba aquí, que se encontraba en México y que no sabía cuándo regresar.
What I know is that I visited his mom. His mom said that he wasn't here anymore, that he's in Mexico, and that she didn't know when he would return.
The court has received, reviewed, and considered the motion for citation by publication, including the affidavit by Ms. Garcia. The court finds that there is good reason, cause, and basis to grant the request. Citation will be issued out by publication. The court has signed an order. Ms. Flores, give us a setting in October, please.
October the 4th. October the 14th at 2 p.m.
Me as a clerk's office so that this case is ready on October the 14th. Now that the court has signed the order on the motion for citation by publication, is that process automatic now, or does Ms. Garcia need to take any action?
It would be automatic, Your Honor. We would go ahead and upload the citation to the OCA website.
So we will let that time run so that when we come back on October the 14th, this case, your case, will be ready to be heard. Ms. Catherine Garcia, present by video conference on behalf of the Attorney General's office, would you like to be heard?
Good afternoon, Your Honor. Just a quick, brief comment for the record. Judge, there is a prior SAPSER order. In this case, it's only ordering medical support, but that cause number is 2018 FLH 001575C3. So in the final decree, we're just going to be asking that the court note that the SAPSER is consolidated into this divorce cause.
I will write that into my notes, and when I call this case on October the 14th, if I grant the divorce, I will write that language in.
Thank you, Judge. That's the only comment.
Thank you for bringing that to the court's attention. I appreciate that, Ms. Garcia. Ms. Edith Garcia, do you have any questions for the court?
No, that's all.
I look forward to calling your case on October the 14th. Have a good day.
Page 2, number 4.
Did you say 4? Laida Zugeli Gonzalez versus Miguel Angel Flores Jr., cause number 2026 FLA 720C3. Ms. Gonzalez, Mr. Flores, please step forward. Court marks Ms. Catherine Garcia, present by video conference on behalf of the Attorney General's office. Speak into the microphone and tell the court, are you Saida Sueli Gonzalez?
Saida Sujei Gonzalez, yes, sir.
Welcome to court, Ms. Gonzalez. The court marks you present in person. Are you Miguel Angel Flores Jr.?
Yes, Your Honor.
Welcome to court, Mr. Flores. The court marks you present in person. This is a divorce. Ms. Gonzalez, are you ready to go forward?
Yes.
Mr. Flores Jr., are you ready to go forward?
Yes, Your Honor.
Ms. Flores, does the court have the email addresses for both parties?
Yes, Your Honor.
I guess before I begin, Ms. Gonzalez, are you going to request any modifications to any child support orders for your children?
No, Judge.
Will you be requesting any changes to child support orders of your children, Mr. Flores?
No, Your Honor.
All right. And are you ready to go forward, Ms. Garcia?
Yes, Your
All right. Ms. Gonzalez, Mr. Flores, please raise your right hands. Do each of you solemnly swear or affirm that the testimony you will give in this cause will be the truth so help you God?
Yes, Your Honor.
Yes, Your Honor.
Court has heard yes from both. You may lower your hands. Now that you're under oath, tell the court your true and correct name, Ms. Gonzalez.
Zaida Sujei Gonzalez.
Welcome to court once more. The court marks you present in person. Ms. Gonzalez, you filed this case for divorce on May the 4th, 2026. On that date, had you lived in Texas for 6 months?
Yes, Your Honor.
Had you lived in Webb County for 90 days?
Yes.
Are you currently married?
Yes.
To whom?
Miguel Ángel Flores Jr.
What was the date of your marriage?
September 11, 2000. September 15, 2000. It's been a long time ago. September 15, 2011.
And when did you stop living together as husband and wife?
Since March 2017.
Has your marriage become insupportable with Mr. Flores?
Yes.
Is there any possibility that you reconcile?
No.
Were there any children born in the marriage?
Yes.
How many?
One.
Their age
She's 14 right now
and gender?
as a female.
Were any children adopted of the marriage? Excuse me. Were any children adopted during the marriage?
No.
Are any children expected?
No.
Right. Now you have an Attorney General's Office case that's cause number 2021 FLI 001053C3. In that order and in that case, ostensibly there's some child support orders, visitations, and all of these. Are you requesting the court to modify any of that?
No.
Do you believe that not modifying any of the current orders is in your daughter's best interest?
Yes.
All right. Is there any community property that the court needs to divide?
No, pretty no. I do have 2 vehicles.
Okay, and tell the court what you would like the court to do to each vehicle.
Both of them, I bought them and they're under my name only.
So you bought 2 vehicles, they're both under your name, but what would you like the court to do with those?
I keep them.
Okay. And do you believe that if the court awards those 2 vehicles to you, do you believe that that is a just and right division of your property?
Yes.
Is there any, and what I mean by property, I mean, besides real estate, like vehicles, bank accounts, retirements, savings, any other property that the court should divide?
No.
Ms. Gonzalez, are you asking for a name change?
What, sorry?
Name change?
No, sir.
Is there anything else you would like to tell the court?
No.
Is your true and correct name Miguel Ángel Flores Jr.?
Yes, Your Honor.
Mr. Flores, you heard Ms. Gonzalez testify. Is there anything that she told the court that you disagree with?
No, Your Honor.
She said that keeping all of the current orders regarding your daughter, regarding visitation, conservatorship, child support, and all of these things should stay the same. Do you believe that they should stay the same?
Yes, Your Honor.
Do you believe that that would be in your daughter's best interest?
Yes, Your Honor.
You also heard her testify that she thinks that a just and right division of your property is that she keeps the 2 cars that she took under her name and that she possesses. Do you agree or do you disagree with that?
Yes, Your Honor. I agree.
Do you believe that that is a just and right division of your property?
Yes, Your Honor.
Is there anything else you would like to tell the court?
No, Your Honor.
Any questions for either of the parties, Ms. Garcia?
No questions, Your Honor.
All right. Ms. Gonzalez, Mr. Flores, in your case, cause number 2026 FLA 720C3. At this time, the court finds that it has jurisdiction over your case, meaning this is the proper court form and venue to consider your divorce. The court finds that you entered into marriage on the 15th day of September 2011, but you stopped living together as husband and wife in March of 2017. The court finds that unfortunately your marriage has become insupportable due to a discord or a conflict of personalities that destroys the legitimate ends of the marriage relationship. The court finds that there was one child, a daughter that was born in the marriage. No other children were born, adopted, or are expected. The court finds that it has jurisdiction over this child in cause number 2021 FLI 001053C3. The court hereby consolidates that case into this one without any modification or changes to any of those orders, and the court finds that doing that is in fact in your daughter's best interest. The court finds that there's only two pieces of property that the court needs to divide that are community property. There are two vehicles. The court hereby awards both vehicles to Ms. Gonzalez, and the court finds that doing so is in fact a just and right division. At this time, Ms. Gonzalez and Mr. Flores, the court finds that there is no reasonable expectation of reconciliation, and the court hereby renders and pronounces you divorced.
Thank you, Your Honor.
Give me a second while I review your decree. Ms. Gonzalez and Mr. Flores, the court has signed your divorce decree. I am tendering to the clerk's office the original signed copy. That concludes your divorce. I wish you both very well, but more importantly, I wish your daughter all the best. Have a good day.
Page 7, number 20.
In the matter of Gabriel Tobias Jr., cause number 2021, PB 67L2. Joaquina Rosales, Leticia Flores, if you're present, please step forward. Are you Joaquina Rosales?
Yes.
Welcome to court. The court marks you present in person. Are you Leticia Flores?
Yes.
Welcome to court, Ms. Flores. Court marks you present in person. Ms. Rosales and Ms. Flores, we're here today for a compliance hearing. The court needs to hear in writing from each of you about the well-being of Gabriel. And I think we're pending an annual report from you, Ms. Rosales, as to Gabriel's well-being. I think we may also be pending an accounting of his estate, Ms. Flores. So let me begin by asking you, Ms. Flores, have you had an opportunity to prepare the reports that are due on Gabriel's estate?
Inaudible.
Speak louder into the microphone,
sorry.
please.
I have not prepared them, but we have spoken to Ms. Rodriguez right now.
When you say Ms. Rodriguez, you're talking about Ms. Liza Rodriguez, the court's probate court investigator?
Yes.
Court asserted yes. And based on your conversations with the probate court investigator, how much time do you think you need to prepare those reports?
No more than 15 days.
Ms. Rodriguez, is it only the annual accounts that are missing?
Your Honor, we're pending the annual report for 2024, 2025. And then we're pending as well the annual report and the annual accounting from 2025 to 2026. I explained to Ms. Flores Estrada, and we are going to be in communication. And if she has any questions, I provided her with my information, Your Honor.
Well, it sounds like you're well on your way to having those prepared, Ms. Flores. Ms. Rosales, similar question to you. I think you're missing one report. How much time do you think you require to prepare that report?
Señora Rosales, la misma pregunta para usted. Parece ser que usted solamente necesita completar un reporte. ¿Cuánto tiempo le está pidiendo al tribunal para terminar este reporte?
Pues, 15 días.
Well, 1 week, 15 days.
All right, Ms. Noriega, give us the next self-represented litigant docket date, please.
That'll be September 2nd at 2 p.m., Your Honor.
All right, so come back to court then, but fill out the reports well before. Do you have any questions for the court, Ms. Rosales?
Su siguiente audiencia es el 2 de septiembre a las 2 de la tarde. Ese día regresarán al tribunal. Asegúrese de archivar y completar su reporte mucho antes de esa fecha. ¿Alguna pregunta para el tribunal, señora Rosales? No.
Any questions for the court, Ms. Flores?
No.
I guess just for the record, Ms. Flores, tell the court, how is Gabriel doing?
He's good. He has he's staining from his from the front of his forehead throughout his face, but he's doing good.
Tiene problema mental.
He has a mental issue.
All right, I'm glad to hear that he is doing well and stable. I'll call this case on September the 2nd at 2. Good luck.
Thank you.
Me da gusto saber que él está estable y que está haciendo o está bien. Nos veremos el 2 de septiembre a las 2 de la tarde. Buena suerte. Yes. Page 5, number 12.
Humberto Carlos Juarez versus Fritzi Alexandria Cervantes Gonzalez, cause number 2026 FLB 799C3. Mr. Juarez, Ms. Cervantes Gonzalez, if you're present, please step forward. Speak into the microphone as close and as loud into the microphone as you can and tell the court, are you Humberto Carlos Juarez?
Yes, sir.
Welcome to court, Mr. Juarez. The court marks you present in person. Are you Fritzi Alexandria Cervantes Gonzalez?
Yes.
Welcome to court, Ms. Gonzalez. Court marks you present in person. Mr. Juarez, you filed this divorce. Are you ready to go forward?
Yes, sir.
Court has heard yes. Ms. Gonzalez, are you ready to go forward?
Yes.
All right, court has heard yes. I'm gonna ask that you speak as loud as possible. If you think you're speaking too loud and yelling, that's probably not loud enough, all right? Mr. Juarez, Ms. Gonzalez, please raise your right hands. Do you solemnly swear or affirm that the testimony you will give in this cause will be the truth, so help you God?
Yes.
Both have answered yes. You may lower your hand. Let me begin with you, Mr. Juarez. You're the person that has filed this case. Now that you're under oath, is your true and correct name Humberto Carlos Juarez?
Yes, sir.
Mr. Juarez, you filed this divorce on May 18, 2026. On that date, had you lived in Texas for 6 months?
Yes, sir.
Had you lived in Webb County for 90 days?
Yes, sir.
Are you currently married?
Yes, sir.
To whom?
Fritzi Cervantes. Fritzi Cervantes.
What was the date of your marriage?
October the 20th of 2023.
Let me make sure I got that clear. Tell me the date one more time.
10/20/23.
And when did you stop living together as husband and wife?
March 2024.
Has your marriage to Ms. Cervantes Gonzalez become insupportable?
Yes.
Is there any possibility that you reconcile?
No, sir.
Were there any children born in the marriage?
No, sir.
Were any children adopted?
No, sir.
Are any children expected?
No, sir.
Have you acquired any property with Ms. Gonzalez that the court needs to divide?
No, sir.
Is there anything else you would like to tell the court?
No, sir.
Now that you're under oath, Ms. Gonzalez, tell the court, is your true and correct name Fritzi Alexandria? Excuse me, Alexandri. Help me out.
Alexandrina.
Alexandrina Cervantes Gonzalez?
Yes.
Welcome to court once more. Ms. Gonzalez, you heard the testimony of Mr. Juarez. Is there anything he testified to that you disagree with?
No.
Are you asking this court for a name change?
No.
Is there anything else you would like to tell the court?
No.
All right. Mr. Juarez, Ms. Cervantes Gonzalez, in your case, cause number 2026 FLB 799C3, the court at this time finds that it has jurisdiction over your case, meaning this is the proper court form and venue to consider your divorce. The court finds that you entered into marriage on the 20th day of October 2023, but you stopped living together as husband and wife on the 20th day of March 2024. The court finds that your marriage has become insupportable due to a discord or a conflict of personalities that destroys the legitimate ends of the marriage relationship. The court finds that there were no children born, adopted, or are expected of the marriage, and the court finds that there is no community property for the court to divide. At this time, Ms. Juarez, Mr. Juarez, and Ms. Cervantes Gonzalez, the court finds that there is no reasonable expectation of reconciliation, and the court hereby renders and pronounces you divorced. In a few minutes as I review your decree. Just one area that the court needs to clarify, Mr. Juarez, you've listed a property on 1307 Green Top as separate property. Are you wanting the court to confirm that that is your separate property?
Yes, sir.
Did you purchase this home on or after, before or after October the 20th, 2023?
Before.
Okay. Do you disagree with that, Ms. Cervantes Gonzalez?
No.
The court confirms that property is in fact separate property. Mr. Juarez, Ms. Gonzalez, the court has signed your divorce decree. Your divorce is final. I wish you both very well.
Page 5, number 14.
Maria Luisa Garza versus Juan Ricardo Guajardo, cause number 2026 FLB 847C3. Ms. Garza, Mr. Guajardo, if you're present, please step forward. Ms. Garza, speak as loud as possible into the microphone and tell the court, is your name Maria Luisa Garza?
Yes, Your Honor.
Welcome to court, Ms. Garza. The court marks you present in person. Juan Ricardo Guajardo, are you present? Court finds respondent is not present and court takes judicial notice that he was served with process in this case on served with process in this case on June the 1st, 2026. Ms. Garza, are you ready to go forward?
Yes, Your Honor.
Ms. Flores, does the court have Ms. Garza's email address?
Yes, Your Honor.
Ms. Garza, I'm going to ask that you raise your right hand, please. Do you solemnly swear or affirm that the testimony you will give in this cause will be the truth so help you God?
Yes.
You may lower your hand. Is your true and correct name Maria Luisa Garza?
Yes, Your Honor.
Welcome to court, Ms. Garza. Once more, Ms. Garza, you filed this divorce on May 28th, 2026. On that date, had you lived in Texas for 6 months?
Yes.
Had you lived in Webb County for 90 days?
Yes.
Are you currently married?
Yes.
To whom?
Juan Ricardo Guajardo,
What was the date of your marriage?
May 14, 2019.
And when did you stop living together as husband and wife?
The 1st, 2020.
Has your marriage to Mr. Guajardo become insupportable?
Yes, Your Honor.
Is there any possibility that you reconcile?
No.
Were there any children born in the marriage?
No.
Were any children adopted?
No.
Are any children expected?
No.
Is there any community property that the court needs to divide?
No, Your Honor.
Ms. Garza, are you requesting a name change?
No.
Is there anything else you would like to tell the court?
No, Your Honor.
Ms. Garza, in your case, cause number 2026 FLB 847C3, the court at this time finds that it has jurisdiction over your case, meaning this is the proper court forum and venue to consider your divorce. The court finds that you entered into marriage with Juan Ricardo Guajardo on the 14th day of May 2019, but you stopped living together as husband and wife on June the 1st of 2020. The court finds that unfortunately your marriage has become insupportable due to a discord or a conflict of personalities that destroys the legitimate ends of the marriage relationship. The court finds that there were no children born, adopted, or are expected of the marriage, and the court finds that there is no community property to divide. Ms. Garza, at this time, the court finds that there is no reasonable expectation of reconciliation, and the court hereby renders and pronounces you divorced. Give me a minute while I review your decree.
Yes.
Ms. Garza, the court has signed your final decree of divorce. Your divorce is final. I wish you well.
Yes, thank you.
Page 2, number 3.
Maria Guadalupe Vara versus Ociel Alonso Garcia Juarez, cause number 2026 FLA 319C3. Ms. Vara, Mr. Juarez, if you're present, please step forward. Are you Maria Guadalupe Vara?
Yes, sir.
Welcome to court, Ms. Vara. The court marks you present in person. Ociel Alonso Garcia Juarez, are you present? Court finds respondent Juarez is not present in person, not present by video conference, and court takes judicial notice that he signed a waiver filed with his court March 4th, 2026. Ms. Vara, are you ready to go forward?
Yes, sir.
Would you raise your right hand? Do you solemnly swear or affirm that the testimony you will give in this cause will be the truth, so help you God?
Yes, sir.
You may lower your hand. Now that you're under oath, is your true and correct name Maria Guadalupe Vara?
Yes, sir.
Ms. Vara, you filed this divorce on March 4th, 2026. On that date, had you lived in Texas for 6 months?
Yes.
Had you lived in Webb County for 90 days?
Yes.
Are you currently married?
Yes.
To whom?
Ociel Alonso Garcia Juarez,
What was the date of your marriage?
March 16, 2007,
When did you stop living together as husband and wife?
February 2019.
Has your marriage to Mr. Garcia Juarez become insupportable?
Yes.
Is there any possibility that you reconcile?
No.
Were there any children born in the marriage?
Yes.
How many?
3.
Their ages?
18, 14, and 9.
Now, you don't have an open case. You filed a case and that was dismissed in 2025. So let me ask you this. For your 3 children, you said you have an 18, a 14, and a 9-year-old. What is the gender of the 18-year-old?
He's male.
The 14-year-old?
Male.
And the 9-year-old?
Male also.
Has the 18-year-old graduated from high school already?
He graduated, but he has a disability. He's autistic.
Has he been formally diagnosed as autistic?
Yes, he's autistic, diagnosed and everything.
When was he diagnosed?
3 years.
3 years ago?
No, when he was 3.
Oh, I see. When he was 3. So 15 years ago.
Yes, sir. I'm sorry.
Just want to make sure we have a good record.
I'm sorry. Yes.
That's okay. And is he able to work, study, take care of himself, or does he need assistance with anything?
No, he's still dependent of me. He needs he needs assistance for everything.
Explain to the court how.
He's not capable. He barely speaks very little. He's not capable of working or being alone. He has to be taken care of. Somebody has to be with him all the time. In the house as well, he needs help for his grooming, for his necessities. I have help also from a service provider for him.
Yeah.
She goes and helps me out with him too.
Do you have an agreement with Mr. Garcia Juarez about visitation, custody, and child support?
Yes.
What is that agreement?
The agreement?
Yes.
Like financially or?
On anything regarding the children, do you have an agreement with Mr. Juarez?
Yes, he is giving me, he gives me child support every week. 200. He gives me 200. He's been like that. We've been like that for years already. He's not, he can't legally, he doesn't have permission to legally work here since he's from Mexico. So he doesn't have a social security or anything like that.
Understood.
We have like an agreement. I'm sorry to interrupt.
Yeah.
I did bring an affidavit about what he gives me that I signed with a notary public.
And does that affidavit say that he gives you $200 a week?
Yes, sir.
And do your children have health insurance?
Yes.
Is it private or public?
It's Medicaid.
Do they have dental insurance?
Yes,
through,
the kids have through the Driscoll. And my oldest one, which is autistic, he has through the Social Security.
all right, are you asking the court to continue this agreement with Mr. Garcia Juarez, or are you asking that the court do something different?
No, I continue with the same agreement. We haven't had any problems ever.
Do you believe that that agreement is in your three children's best interest?
Yes, sir.
Is there any community property that the court needs to divide?
No.
Ms. Garcia, do you have any questions for Ms. Vara? Oh,
No.
for the record, Ms. Catherine Garcia is present, participating by video conference on behalf of the Attorney General's office. I don't think the AG's office is part of this case, but if you're welcome to ask questions if you have any for Ms. Vara.
Your Honor, I don't have any questions, but I would like to make a comment to the court as far as the medical support.
Yes, ma'am, go ahead.
As far as if their agreement is $200 every week on the child support, that's fine, but we will need some step downs for the other two children. And then on the medical, we would, since there are three children, we would ask the reimbursement to be $100 a month.
Right. Ms. Garcia, let me ask you this. I completely agree with you, and I would do that under normal circumstances. But I believe that the court is about to make a finding that the oldest child is disabled, or at least medically and physically unable to care for himself or work. So it's very likely that the court is going to order $200 per week with no step downs. Does the AG's office have any thoughts, opinions, or objections to that?
No objections, Your Honor, other than just if the court could include a finding, and it would be indefinite support, a finding that the child needs. I'm not sure what the legal buzzword is, but I believe it's continuous supervision and is incapable of self-supporting. But it's a finding of indefinite support.
All right.
And for that particular child.
Now, I need to ask you the same question, Ms. Vara. I'm about to pronounce and render that decision. Before I do you have any objection to that? So in other words, what I'm saying is I'm about to order Mr. Garcia Juarez to pay $200 for the life of your oldest son. But before I make that decision, you have the right to give the court your opinion. Is there anything you want the court to know about that?
No.
All right. Anything else to put on the record on this case, Ms. Garcia?
No.
Oh. No, Your Honor.
No worries. Anything else to put on the record on this case, Ms. Vara?
No.
All right. Ms. Vara, in your case, cause number 2026 FLA 319C3, the court at this time finds that it has jurisdiction over this case, meaning this is the proper court form and venue to consider your divorce. The court finds that you entered into marriage with Mr. Ociel Alonso Garcia Juarez on the 16th day of March 2007, but you stopped living together as husband and wife in February of 2019. The court finds that unfortunately your marriage has become insupportable due to a discord or a conflict of personalities that destroys the legitimate ends of the marriage relationship. The court finds that there were 3 children born in the marriage. No other children or born adopted are expected. Of those 3 children, 2 are minors. The court finds that the oldest, the 18-year-old, is incapable of caring for himself. The court finds that he needs continuous support, and the court orders indefinite support for him. The court finds that you have an agreement with Mr. Garcia Juarez for the payment of $200 per week, and that has been your agreement for years. The court orders that payment indefinitely as indefinite support, given that your oldest child needs support for life. The court finds that this is in the best interest of all of your children. The court finds that they are currently insured with Medicaid. The court orders a reimbursement of $100 per month by Mr. Garcia Juarez to the state. The court finds that this is in the children's best interest. The court finds that there is no community property to divide, and at this time, Ms. Vara, the court finds that there is no reasonable expectation of reconciliation, and the court hereby renders and pronounces you divorced. Let me make those modifications to your decree. Ms. Vara, the court has reviewed your decree. I have signed it. Your divorce is final. I wish you very well.
Thank you.
Page 8, number 23.
In the matter of Hector X Lara, cause number 2026 SME 13L2. Edil Lara, if you're present, please step forward.
There's a letter on file requesting another hearing date.
It was filed by Ms. Lara.
Good afternoon, Your Honor.
Good afternoon. Speaking to the microphone and tell the court, are you AD Lara?
Yes, I am.
Welcome to court, Ms. Lara. The court marks you present in person. You're here on a small estate affidavit, but you filed a letter. Tell the court what you would like the court to do.
Yes, I was requesting some more time for another, another date for the court because I haven't had the chance to get all the paperwork together.
All right. Court request is well taken. Give us that next setting. All right, so this is just a submission deadline. So just file into the case anything that you want the court to consider. And on that date, I'm not going to call the case. It's by submission, which means I'm going to review the file. If everything is good and ready, I'm going to sign off on it.
Okay.
Do you have
Thank
any
Your-
questions for the court,
Thank you,
Ms.
Your
Lara?
Honor. No questions, Your Honor. Thank you.
All right, have a good day. I wish you well.
Thank you.
Your Honor, may we call page the rest of the L2 cases?
Yes.
Page 7, number 18.
In the matter of Gloria Elizabeth Martinez, cause number 2012, PB 663L2, Blanca Irma Zapata, are you present?
Not present or identified.
This is a compliance hearing. Court finds that the guardian is not present. Let me hear from the court coordinator or the probate court investigator on the status of this case.
Gloria Noriega for the record, Your Honor. As per my last phone call with Ms. Zapata, her emails were not on the guardianship reports. So I finally got a hold of her via phone call and she gave me her email. So I emailed her all the information last week on Friday,
All right, so give me the date for another compliance hearing.
September 2nd at 2 p.m.
So ordered. In the matter of Gabriela O. Trevino, cause number 2019 PB 623L2, Odilia Izaguirre, are you present?
Not present or identified, Your Honor. Just for the record, annual report has been filed and approved.
Court finds that this case is in compliance.
Page 9, number 4.
In the matter of Jesus Aragon, cause number 2026 SME 18L2, Ramona Aragon, are you present?
Present or identified.
Finds the applicant is not present. This is a second docket control conference. Has anything been filed?
No, Your Honor.
This case is hereby dismissed for want of prosecution. Court will prepare its own orders.
Thank you, Your Honor. Page 3, number 8.
Miriam Marquez versus Francisco Javier Rodriguez, cause number 2026 FLA 842C3. Ms. Marquez, Mr. Rodriguez, if you're present, please step forward. Court finds Ms. Catherine Garcia is present and participating by video conference on behalf of the Attorney General's office. Speak loudly into the microphone and tell the court, are you Miriam Marquez?
Yes, sir.
Welcome to court, Ms. Marquez. The court marks you present in person. Are you Francisco Javier Rodriguez?
Yes.
Welcome to court. The court marks you present in person. Ms. Flores, does the court have email addresses for both?
Yes, Your Honor.
Ms. Marquez, are you ready to go forward?
Yes, sir.
Mr. Rodriguez, are you ready to go forward?
Yes.
I'm going to ask that you both raise your right hands. Do each of you solemnly swear or affirm that the testimony you will give in this cause will be the truth, so help you God?
Yes, sir.
Yes.
Both have answered yes. You may lower your hand. Let me begin by asking you some questions, Ms. Marquez, because you're the person that has filed for this divorce. You filed this case on May 27, 2026. On that date, had you lived in Texas for 6 months?
Yes, sir.
Had you lived in Webb County for 90 days?
Yes, sir.
Are you currently married?
Yes.
To whom?
Francisco Javier Rodriguez.
What was the date of your marriage?
May 10, 2013.
When did you stop living together as husband and wife?
October 2022. 22.
One more time. When did you stop living together?
October 22. 2022, sorry.
Mhm. And has your marriage to Mr. Rodriguez become insupportable?
Sorry?
Is there any possibility that you reconcile with Mr. Rodriguez?
No, sir.
Were there any children born in the marriage?
Yeah, 5.
Their ages?
14, 13, 10, 7, and 4 years.
You have a case in 2024 FLI 1417C3. Does that case order Mr. Rodriguez to pay child support?
Yes.
Are you asking the court in here, in this case, to make any changes or modifications to child support or parental rights?
No, sir.
Do you believe that leaving everything the same would be in your 5 children's best interest?
Yes.
Ms. Marquez, is there any community property that the court needs to divide?
No, sir.
Are you asking the court to change your name?
No.
Is there anything else you want to tell the court?
No, sir. I'm fine.
Is your true and correct name Francisco Javier Rodriguez?
Yes.
Mr. Rodriguez, you heard the testimony of Ms. Marquez. Is there anything that she testified to that you disagree with?
No, that's fine.
No, everything's fine.
Regarding her request to leave everything the same regarding child support and visitation, do you believe that not making any changes would be in your 5 children's best interest?
Yes.
Is there anything else you want to tell the court?
No.
No, nothing.
Ms. Garcia, do you have any questions for either or both of the parties?
Your Honor, I have no questions. Just to make a comment to the court.
Yes, ma'am, go ahead.
And Judge, so this is a 2025 SAPSR order that orders child support and medical support. And Your Honor, if the court could just indicate on the decree that the SAPSR cause is consolidated into the divorce cause and that all terms of the prior SAPSR order are to remain in full force and effect. And that way the AG's office will know to keep the order in place.
Any objection to the court doing that, Ms. Marquez?
No.
Any objection to the court doing that, Mr. Rodriguez?
No.
Ms. Marquez, Mr. Rodriguez, in your case, cause number 2026 FLA 842C3, the court at this time finds that it has jurisdiction over your case, meaning this is the proper court form and venue to consider your divorce. The court finds that you entered into marriage on May the 10th, 2013, but you stopped living together as husband and wife in October of 2022. The court finds that your marriage, unfortunately, has become insupportable due to a discord or a conflict of personalities that destroys the legitimate ends of the marriage relationship. The court finds that there were 5 children born to the marriage. No other children were born, adopted, or are expected. The court finds that child support obligations and parental rights have been ordered in cause number 2024 FLI 001417C3. The court hereby adopts and incorporates those orders and consolidates that case herein. And the court finds and orders that consolidating all of the terms and all of those terms remaining in full force and effect are in your children's best interest. The court finds that there is no community property divide. This time, Ms. Marquez and Mr. Rodriguez, the court finds that there is no reasonable expectation of reconciliation, and the court hereby renders and pronounces you divorced.
Thank you, sir.
Let me just review your decree before you leave. Ms. Marquez, Mr. Rodriguez, the court has signed your decree of divorce. It is final. I wish you both very well. More importantly, I wish your 5 children all the best. Have a good day.
Thank you.
The court will stand at ease momentarily. Court is back on the record. This is a self-represented litigant docket for Wednesday, August 5th, 2026. The time is now 4:10. Ms. Flores.
Page 6, number 17.
Maria Cristela Viejo versus Samuel Sanchez, cause number 2025 FLA 873C3. Ms. Viejo, Mr. Sanchez, if you're present, please step forward. Are you Maria Cristela Viejo?
Yes.
Court marks you
Yes.
present in person. Samuel Sanchez, are you present? Court finds Mr. Sanchez is not present in person, not present by video conference. Ms. Viejo, we're here because Samuel Sanchez filed a motion for enforcement of possession and access in April, but he's not here today. And in July, the court ordered both you and him to test for drugs. You tested negative, and he decided not to test. What would you like the court to do regarding the motion of enforcement for possession and access?
Quiero tomar la custodia 100% del niño. No quiero que él tenga decisiones sobre él y aceptar la decisión de los niños que no quieren verlo, porque pues él es muy responsable con ellos, cómo se los lleva.
Translation, please.
I want to have 100% custody over the children. I do not want him to have access to the children and for the children's decision of not seeing him to be accepted, because when they see him, he's very irresponsible with them.
Mhm. What does the current order in place, what does that order the parties? That both of you have joint managing conservatorship and equal rights, or something different?
Pues tenemos la custodia la estándar, un fin de semana él, un fin de semana yo, pero yo soy la que tiene más derecho.
We have standard custody. We share one weekend each. One weekend is my turn, one weekend is his turn. And I have the one that has greater access to the children.
Ms. Viejo, would you raise your right hand? Do you solemnly swear or affirm that the testimony you will give in this cause will be the truth, so help you God?
Yes,
You may lower your hand. Is your true and correct name Maria Cristela Viejo?
yes, yes,
Is everything that you've told the court true and correct?
yes.
Remind the court, when we were last here in July, there was a reason why the court ordered the parties to be tested for drugs. What was that reason?
Pues solo recuerdo que nos mandó a hacer la prueba de drogas, él se negó y yo sí me la hice, y usted puso que podría visitarlo usted a un día, 2 horas supervisadamente, pero no asistió. No.
Translation.
The only thing that I remember is that you ordered for us to take the drug test. He did not comply. And you ordered for a visit to take place on a specific day for 2 hours. Supervised, and he did not assist.
Right, but the question the court has is, why did the court order that drug testing? Did you accuse Mr. Sanchez of something, or did he accuse you of drug use?
Sí, así es, porque yo dije que estaba
Yes, because I told the court that he uses drugs when he's with the children.
And what's good for one is good for all, so the court ordered that both be tested.
Exactly.
You submitted to the testing and came back negative, and he completely declined to do so.
Yes,
So based on all of this, what is your request to the court?
Pues no quiero que ya no los vean, porque no me siento a gusto a yo prestarle a mi niño y que estén corriendo algún riesgo con él.
I don't want him to see them anymore because I don't feel safe that my children could have something happen to them when they are with him.
It's Viejo in this case, cause number 2025 FLA 873C3. The court finds that it has continuing exclusive jurisdiction over this matter. Mr. Sanchez isn't here to urge his motion for enforcement. It is denied. Based on your testimony and what has happened here in court, the court grants your request, names you as the sole managing conservator over your children. Mr. Sanchez is named as the possessory conservator. All visitations shall be supervised, and there are no other modifications made. The court does this in the best interest of your children. The court has signed an order to that effect, and the court wishes you very well. Do you have any questions for the court? Good
No,
luck.
that's all. Thank you very much.
Thank you. Good luck.
Page 5, number 13.
Andrea Guerrero versus Jose Adan Romero Buchert, cause number 2026 FLB 830C3. If you're present, please step forward. Ms. Guerrero, please speak into the microphone and tell the court, are you Andrea Guerrero? Welcome to court, Ms. Guerrero. The court marks you present in person. Jose Adan Romero Buchert, are you present? Court finds that respondent is not present. The court finds that he filed a waiver July 16, 2026. Ms. Guerrero, are you ready to go forward? I'm going to ask that you raise your right hand. Do you solemnly swear or affirm that the testimony you will give in this cause will be the truth, so help you God? You may lower your hand. Is your true and correct name Andrea Guerrero? Welcome to court, Ms. Guerrero. You filed this divorce on May 22nd, 2026. On that date, had you lived in Texas for 6 months? Had you lived in Webb County for 90 days? Are you currently married? To whom? What was the date of your marriage? When did you stop living together as husband and wife? Has your marriage to Mr. Romero become insupportable? Is there any possibility that you reconcile? Were there any children born in the marriage? Were any children adopted? Are any children expected? Did you acquire with him any community property that the court needs to divide? Ms. Guerrero, are you requesting a name change? Is there anything else you would like to tell the court?
No.
Ms. Guerrero, in your case, cause number 2026 FLB 830C3, the court at this time finds that it has jurisdiction over your case, meaning this is the proper court forum and venue to consider your divorce. The court finds that you entered into marriage with Mr. Romero Buchert on the 16th day of December 2022, but you stopped living together as husband and wife in February of this year, 2026. The court finds that unfortunately your marriage to Mr. Romero has become insupportable due to a discord or a conflict of personalities that destroys the legitimate ends of the marriage relationship. The court finds that there were no children born, adopted, or are expected of the marriage, and the court finds that there is no community property to divide. At this time, Ms. Guerrero, the court finds that there is no reasonable expectation of reconciliation, and the court hereby renders and pronounces you divorced. Let me just review your decree so that we can make it final. The court has signed your final decree of divorce. Your divorce is final. I wish you well.
Next page, page 6, number 15.
Edgar Rodriguez Jr. versus Grecia Galo, cause number 2026 FLE 896C3. Edgar Rodriguez, Grecia Galo, are you present? Please step forward. And the court finds and marks Ms. Catherine Garcia present and participating by video conference on behalf of the Attorney General's office. Speaking to the microphone and tell the court, are you Edgar Rodriguez Jr.?
Yes, sir.
Welcome to court, Mr. Rodriguez. The court marks you present in person. Speaking to the microphone and tell the court, are you Gracia Galo? Yes, court staff, if that was loud enough.
Could be louder, Your Honor.
Are you Gracia Galo?
Yes.
Welcome to court, Ms. Galo. The court marks you present in person. It's a petition to terminate and to modify a prior order. There is an AG's office petition, excuse me, an open case. Miss, who is the petitioner? Are you making this request, Mr. Rodriguez?
Yes, sir.
Do you have any opposition to this request, Ms. Galo? Court has heard no. Does the Office of the Attorney General have any position one way or the other?
Your Honor, Catherine Garcia for the Attorney General's office. Your Honor, this case, we do have an open SAPSR from an agreed order that the parties entered into back in 2023. There are child support and medical support obligations in place. We did not receive a copy of this suit for termination, so I had not been able to file an answer. However, we are making an appearance. We would file an answer and request that, you know, the party met the burden of proof of clear and convincing evidence. We would also be requesting the appointment of an ad litem to represent the interest of the child. And Your Honor, also, I would like to inform the court that we have not entered a modified 2025. That order is not entered. We don't have that order running. So we don't have the correct number, arrears balance in our system. So for us to get the correct orders entered, the correct arrears balance is going, and also for the AG's office to file an answer.
All right, so I'm going to give you two, well, before I make a decision, Mr. Rodriguez, you heard the request from the Attorney General's office. Do you agree or do you have an objection to that request?
No, but I did get I don't know if it came to an agreement or what I got an email for $130 a month for that. I just got it like a week ago, I guess.
Sure, but whatever information you got from the Attorney General's, whether it's one thing or something else, the request here is that they be given time so that they can receive the documents and prepare adequately before going forward. Do you have any objection to that request?
No, sir.
Same question to you, Ms. Kalo. The request by the AG's office is to receive the documents that were filed into the case so that they can adequately prepare. Do you have a response or an objection to that?
I would like for this to be faster since child is about to start school. And I would like to request a name change.
So I like the request, Ms. Galo, because I think all cases should be heard as quickly as possible. This case and all cases, so that everybody can go on with the rest of their lives, whatever the decision is. In this case, I think the AG's office is making a good request, because if I deny their request, they can come back and complain and say they didn't receive the documents that you all filed into the case, and they would be completely right. That they legally are entitled to an opportunity to receive, review, respond, and prepare adequately. So they can, even if we went forward, they can come back and undo the entire thing. And whatever happens in this case, I want to do this once. I want to do it good. And I really want to reduce the possibility that anybody will complain about this later. So I'm going to give you 2 dates so that when this happens, whatever decision the court makes will be as airtight. It'll be legal in any event, but it'll be as airtight as possible. So the first hearing is a final pretrial hearing on
September 2nd at 2 p.m.
And the final hearing is on
October 14th at 2 p.m.
the first hearing is so that the court can confirm whether the Attorney General's office has been served or whether they have received a copy. What is the AG's preference, Ms. Garcia? Or the requirement?
Your Honor, we have pulled a copy of the termination suit, so I do have it. But I reviewed the cases today and just saw this case, so I have not had a time to prepare an answer. So we can get an answer on file fairly quickly.
All right. So we're going to come back on September the 2nd to confirm whether an answer has been filed. And we're also, the court will prepare its own order appointing an ad litem. And we'll get that on file within a few days. And we're going to come back on September the 2nd to confirm whether that lawyer has had an opportunity to meet with Ms. Calo, to talk to Mr. Rodriguez, to interview the child and perform any services that are necessary. And then we'll come back on October the 14th for a final hearing. Mr. Rodriguez, Ms. Calo, make yourselves available to the ad litem attorney. The court, unless you present evidence as to why the court should not do this, the court will order that each of you pay that lawyer 1/2 each. Do you have any questions for the court, Mr. Rodriguez?
No, sir.
Any questions for the court, Ms. Calo? Into the microphone.
What if I'm not so interested about how much money he has to pay me?
Well, you can tell the court and you can tell the Attorney General's office that you would like to relinquish whatever you want. Remember that you can make that request. It's your child's money, not necessarily yours, but you're the person that manages that money. But the court is also going to hear from the attorney ad litem because that person doesn't represent you, doesn't represent Mr. Rodriguez, and that person will tell the court what in their professional judgment they believe is in this what's best for this child. So you may want to relinquish the money and that person may say that the child should have their money, or they may agree with you or something different. I don't know, but at least that gives the court a perspective of someone that isn't Mr. Rodriguez, isn't Ms. Calo, and isn't the state that can represent the child in this case. So do you have any other questions, Ms. Calo?
So even if I'm fine with not receiving the money, it's still gonna be the same process, right? Like, just because I don't want the money, it won't make it faster.
That's right. It's not going to make the process faster. The court tries very hard to approve the agreements of the parties. However, if there's an agreement, it's binding on the parties. It's not binding on this court. The court can say, I absolutely agree that this is in the best interest, or I could say, it's not in the best interest of this child. You all can agree to whatever, but I don't agree to that. So all that to say, I do try very hard to approve agreements, but I'm certainly not bound to those. All right. Do you have any other questions?
There's no paper stating that this process has started, so at child's school, I can present it. Like, so they can see that her name is going to change, because she doesn't know the last name she has right now. She only knows what she has lived with since forever.
How old is this child?
She's about to be 5 in November. I mean, what I'm saying is just so she won't be confused in school as to, I grew up with this last name and now my teacher is presenting me with this other last name that she has no clue about.
Well, I can see the difficult situation, and I understand that. And I guess the best I can tell you is that we're talking about very different things. I can only tell you what's happening in the legal system, and I can't make any decisions until Ms. Garcia or the Attorney General's office has had a chance to prepare. I can't and won't make any decisions until that attorney ad litem come back and says, Mr. Rodriguez and Ms. Calo are completely right, and I agree with this, or something different. Until that happens, officially and legally, that name won't change. Now, that's different. This legal system world is different from the educational system. You can present whatever documents and information, and together you may be able to convince them to do something else in your child's best interest. But I don't control what their policies and procedures are regarding that. What I would let them know, because it's the truth, is that we're going to come back to court in September to make sure that this case is on track, and that's really what we're doing, and that we're going to have a final hearing so they can expect to receive a final signed order right after October the 14th. If that helps you communicate that to them, I would suggest you do.
Okay, that's fine.
Any other questions?
No, that's it.
I hope that answers everything. Ms. Flores.
Yes, Your Honor, if they can please provide me with the email address. both of
Mr.
the parties.
Rodriguez, what is your email address?
Edgar.Rodriguez.
Say that again.
0240. Edgar.Rodriguez 0240 @gmail.com.
Did you get that, Ms. Flores?
Please repeat.
Edgar.Rodriguez 0240 @gmail.com.
FYI, Gmail is one of the email providers where the periods don't matter. You can send an email to that address with or without the period and it'll still arrive, FYI.
Oh.
Ms. Gayla, but you should use it because it's there. Ms. Gayla, what is your email address?
It's GreciaG27@hotmail.com.
Did you get that, Ms. Flores?
Yes, Your Honor.
All right. I look forward to calling this case on September the 2nd. I wish everyone well. Good luck.
Yes, sir.
Thank you.
Thank you. Have a good day.
And Your Honor, that's all the cases the AG has this afternoon. May I be excused?
Thank you for your presence and assistance and participation, Ms. Garcia. Have a great day.
Thank you. You also, Judge.
Next case, Your Honor.
Yes.
Page 1, number 2.
Jessica Gomez, Eduardo Garza, cause number 2023 FLA 247C3. Speaking to the microphone and to the court, are you Jessica Gomez?
Yes, Your Honor.
Welcome to court, Ms. Gomez. Court marks you present in person. Speaking to the microphone and to the court, are you Eduardo Garza?
Yes, Your Honor.
Welcome to court, Mr. Garza. The court marks you present in person. We're here for an entry of judgment. Ms. Gomez, you filed a motion for enforcement. Tell the court what the status is, Ms. Gomez.
Everything remains the same. There has been no payment, no, I was just waiting to come back to court. So we can figure something out today.
The Attorney General's office just logged off, but we're here on an entry of judgment. Remind the court, Ms. Flores, was the court to receive an order? Or you tell the court, Ms. Gomez, what happened at the last hearing?
No, I don't recall, to be honest, that I was ordered to.
But what happened at the last hearing?
We just went over the amount that was owed for the child support. You went ahead and made the judgment, so we're here today. Or you, I don't know how to say. You agreed to set up the judgment for today. Because Eduardo was to provide proof that he had supposedly been paying for all these months because he didn't have the proof that day.
That makes more sense.
Yes.
You alleged that he hadn't paid anything, and he alleged that he didn't have any proof. So the court said, well, you owe all this money, but if you want to provide proof that you have paid, you can come back and provide that. Mr. Gomez, have you uploaded any proof of child support payments to Case Center?
Mr. Garza.
Pardon me, Mr. Garza. I apologize. Have you uploaded your proof of payment to Case Center?
Yes, I came here to the second floor personally, and I submitted copies of the payments that she allegedly said that I wasn't paying.
Have you had an opportunity to receive and review those, Ms. Gomez?
No, Your Honor, because I was not aware of that.
I'm just going to tell you what's been filed into the case. It's not evidence because he hasn't testified to it, but he submitted child support payment information for June the 1st for $1,901. June the 3rd for $1,899. June the 29th for $1,899. The difference in payment for February 2026, 1,901, March 2026, 1,899, April 2026, 1,899. May 2026, 1,899. Including nominal $1.50 fees, and June 2026 for 1,899. Are you disputing these payments?
No, the thing is that I don't know where it's going to because I have not received anything in the child support account or the debit card. So I don't know. I'm not aware where he's depositing that money because he doesn't communicate.
So you don't dispute that he paid it. What you do dispute is that you've received it.
I have not received it.
So, Mr. Garza, the documents that you filed into the case, tell the court what that shows.
Those copies shows all the payments that she's been claiming that I haven't paid. And I wanted to talk to Ms. Catherine.
But tell the court these accounts are what, your personal account and her personal account, or your personal account and the AG's account? What is this?
This is like a alternated website for me to submit child support payments, and it's just coming from the child support office.
So this is a government record.
I assume, yes.
So all of these payments, these are not direct payments to Ms. Gomez.
No, this is to this website that will transfer those funds to her child support account.
And all of these amounts, they reflect payment into that account from a Bank of America, Bank of America account, a JP Morgan Chase account, Bank of America, JP Morgan Chase, and Bank of America. Are those your accounts?
Yes.
Has that money been debited from your account?
Yes.
And those amounts have left your account?
Yes.
And those amounts are no longer in your account?
No longer.
So the court did find Ms. Gomez at the last hearing that he did owe you this money.
Yes.
And then he said that he was going to provide this information, and he now has. So I tell you what, I am going to reschedule this entry of judgment for the very next self-represented litigant docket.
September 2nd at 2 p.m.
Because I think what's going to happen, Ms. Gomez, my best guess, it's just a guess. I have no information that this is actually true and correct. My guess is that he's opened up, for lack of a better analogy, his side of the faucet. You need to go down to the AG's office and open up your side of the faucet to connect your account to that account. In other words, all that money the state has ready for you for delivery into your account.
Okay.
So once that happens, I suggest you go and give your information, give them your bank account or whatever routing information. And then after doing that, they can tell you of the 11,000, he's paid 12,000, you owe 1,000, or he's still missing 5,000 or whatever the case is. And you can come back on that entry date and say, Judge, you were wrong. He owes me the whole thing, or Judge, you were right. And we're tablas. We're even at this point.
Okay.
Right. But talk to them, because it sounds like all of that money is waiting for you.
Okay.
Mr. Garza.
Your Honor, if I may, there's no way we could connect Ms. Garcia, right? Because I was the first one on the page and they kept me until the end. And I think we could avoid this situation by going by the list they had in the front.
We could have avoided the situation had Ms. Gomez gone down to the AG's office to avoid all of this. But she may not have known. So I'm not saying it's your fault. I'm just saying we take persons in the order of appearance that the cases are ready. It just so happened this one wasn't ready in comparison to all the rest. I'm not saying you did anything wrong. I'm just saying the only one here that could have prevented them with the right information, and you may not have had that, was Ms. Gomez.
I'm sorry, Your Honor. I tried. I don't remember if you recall that I had said on the last hearing that I did reach out to the Attorney General several times.
How so?
No payment. I did say that last.
How did you communicate with them?
I have this like Zoom QR code that I do Zoom with them, and that's where we go over, the account and what's been paid, what
How
has
do you,
not.
like,
And they never told me that he had been making payments. So that's the reason why I filed for that. If I hadn't known, I would have been here wasting the court's time, to be honest.
it's not a waste of my time. I very much,
And I apologize because I
no,
was not
no
aware.
need to. I'm here for you all. More importantly, I'm here for your kids. If there was, I promise you, if there was an easier, faster, more efficient way to do this, I would have done it. I tell you what, let me ask our court clerk and coordinator to print out a true and correct copy of the filings by Mr. Garza and tender that copy to Ms. Gomez.
Please.
Take that to the Attorney
Thank you.
General's office and see if they can connect the dots for
Okay.
you.
Will do. Thank you.
Give me 1 second while I can confirm that they've done that. As they do, Mr. Garza, do you have any questions?
Yes, Your Honor. Question, what will be the best venue for me to modify child support orders? Will be here in court with Ms. Garcia present, or I have to go to the office? Guide me there. Because I was expecting to talk to her about that as well.
I think you need to do the same thing that Ms. Gomez is doing, but in reverse. So she's going to go over and talk to them about receipt of those payments. Court is admitting Ms. Garcia. Court marks Ms. Garcia, Ms. Catherine Garcia, present and participating by video conference on behalf of the Attorney General's office. Ms. Garcia, I know the court excused you, and then I don't know if you were still watching, but your name was invoked because the Attorney General's office, I think, is a participant or somehow involved in this case. Are you up to speed with what the court has said?
No, Your Honor, I just got the email from your staff and I'm not sure which case we're on.
This is page 1, case 2, Gomez versus Garza, 2023 FLA 0000247C3.
Okay.
Ms. Garcia, in this case, at the last hearing, the court found that Mr. Gomez was delinquent in child support in the amount of $11,190. He, in response, said that he had proof that he had, in fact, made payments. So then I set this case as entry of judgment today just to enter in the true and correct amount minus whatever evidence he can provide. He filed into the case 5 pages of proof of payment for the months of February 2006, March 2026, April 2026, May 2026, and June 2026, and the amounts ranging from $1,901 to $1,899 per month. In the court's very cursory review of those documents, it sounds like, well, he's telling the court that that's a government account. So it sounds like he's paying the AG's office, but it sounds to the court like Ms. Gomez may not be current in the payment systems with that. If you can provide any relevant information, the court would appreciate.
Sure, Judge, I'll be glad to. What we have running, it looks like there was an active divorce decree for child support of $2,500 a month that stopped in 2024. There's a new order, child support review order of child support of $655 a month, and that was to begin in 2023. I can't verify these dates without pulling the actual orders up. What my system is showing, and I haven't pulled the FINA, but it does say there's collections coming in. So I don't have any collections posted between June of 2025 and June the 8th of 2026. But coming to the AG's office, I've got collections on June the 8th, June the 10th, July the 6th, July the 8th, and there are $1,897.50. So that's 1, 2, 3, 4, 5. There are 5 credits that are posted in 2026, all in the amount of $1,897.50.
That's the exact documentation that Mr. Garza has provided the court. Ms. Gomez in response says, I don't know what that is. I haven't received that money. What is the best thing that the court can indicate to her on how best to receive that money?
So there's a hold on place in this case, and it might be that we're holding those receipts until the financial issue is worked out.
I guess I'm lost. What financial issue must be resolved?
It looks like there's 2 separate clause numbers that
If I may.
there's a little overlap in the times of the accruals, and that has to be looked at more closely. But if on those collections, I'm not sure if they were paid through the AG's office or if those were just credits given to him because he had paid the mother directly.
Ms. Gomez?
Okay, so what I am aware of is that the Attorney General has 2 cases, which was first the 2022 and then the one for our divorce. So I remember when we're going through our divorce, Mr. Guzman, my attorney, filed to consolidate them together. Up until this day, I've been calling the child support because I wanted them to help me enforce, the payments. So they told me, we can't find anything and we don't have anything. We're trying to consolidate both cases together into one, which is the final. So I myself went down to the Attorney General's office. I took a copy of my divorce decree. I handed it to them so that they could generate it into their system and consolidate it into one. So there's a whole, but I'm trying to help as well because I want to make this easy, not even for him too, because it's a big mess up. Yep. it is.
They can't do
And
that. They need they need a court order to consolidate. I think the lawyer should have done it at the time that they were.
Mr. Guzman, and if I may, I let them know that it was filed, and if I recall, they told me it's here. It was filed February of 2024, that order to consolidate. But for some reason, their system is very slow because they changed system, so it has not been able to consolidate since 2024. So
Are you able to confirm that consolidation order, Ms. Garcia?
Judge, I see a consolidation order. And I'm not sure, and don't quote me, but it's a consolidation order signed by Judge Martinez, saying that the SAPSR in County Court 1 is transferred to County Court 3 and consolidated into the County Court 3. So I do see that. But I don't know why, Judge, without looking into it more carefully, why it hasn't been consolidated and what the financial issue is.
If I may,
Yes.
District Clerk,
Yeah.
there was an order to transfer signed by Judge Martinez in the Sapser case, but there was no order accepting for this court to sign.
That's the thing.
Your Honor, if I may.
Yes.
Okay, well, there's a divorce case. I remember the attorney Javier Guzman mentioning to the court in record that he was not update all this information with the Attorney General. Now, I've been getting letters from previous child support orders that I owe a big amount of money with balances on both. So I went to the local office. I showed the lady, the clerk there, the order that Ms. Gomez submitted for this hearing, just pretty much noting that I'm only behind on those payments I just submitted proof of. So. And I believe that's the reason she hasn't received those funds because according to the Attorney General, I owe like $50,000. And that's not the case.
All right,
The last payment I see here was made on July 2 for the month of June. So he also just barely made those payments, Your Honor.
well, I understand that. So I tell you what, it sounds like it's an administrative thing.
Yes.
All over the place. I don't think it's one person or the other. I think one could have turned on the spout, someone could have paid earlier, the consolidation should have happened, it must have been done administratively, the transfer should have happened, there should have been an order accepting. Let me see if I can untangle this as quickly as possible. So the court, if Ms. Garcia is correct, the court is going to prepare its own order. And I'm instructing our staff attorney to do that, an order accepting. And that, Ms. Garcia, is an order accepting the C1 case into the transfer of the C1 case into this case.
Yes, Judge. Yes.
And then the consolidation just kicks in retroactively, does it not?
I don't see why it wouldn't, because that consolidation was signed earlier. I think there's just all these steps have to happen and,
Yeah.
I will get with the financial specialist and find out what, if anything else needs to be done. We may need to go back to the party's attorneys and have them do something, but I will.
They got out of the case a long time ago, and that's why we're here.
Okay.
All right. Court is going to prepare its order accepting. We're going to come back on September the 2nd. Hopefully the court order will be enough to get some traction. And what I mean by that is some ironing out of the issues by the Attorney General's office. And when we come back on September the 2nd, hopefully since all of those cases will be consolidated, it'll turn on the spout to the monies already paid, and then the Attorney General's office will have a true and correct financial activity report that says you owe nothing or you owe $1 or whatever the case is.
Okay.
Any questions, Ms. Gomez?
No, no.
Any questions, Mr. Garza?
Yes, Your Honor. Is there any way Ms. Gomez could testify with Ms. Catherine Garcia about all the payments? Because the issue here is that I'm currently behind from previous orders, and that's not the case.
She could, if she knew what the court has heard, is that she has no idea.
Well, but the reason is, the reason that those funds have been on hold is because the previous orders are saying that I still owe money. That's why she hasn't received those funds. I
Right, so
believe
how
that
can
that's
she
the case.
testify to receiving monies that she doesn't know, hasn't seen, and has no idea of?
Your Honor, she received those paychecks directly through her. I was
Yes.
giving her checks.
Yes, and that
in person.
I will work on it. We'll testify. I mean, I'll say, you know what, he paid me via, directly via check.
Well,
All
Ms.
the-
Gomez, are you prepared to, I will hear the testimony and it'll come in now, but are you prepared to testify as to any and all monies actually received
Yes.
for direct payments? Are you ready to do that now?
Yes,
Ms. Gomez, would you raise your right hand? Do you solemnly swear or affirm that the testimony you will provide in this case will be the truth so help you God?
yes, Your Honor.
You may lower your hand. Is your true and correct name Jessica Gomez?
Yes.
Ms. Gomez, what would you like to tell the court regarding direct payments made by Mr. Garza to you with regard to child support?
I just want the court to know that Mr. Garza has been paying me via checks directly for the past,
Throughout the divorce case.
throughout the whole divorce, but the payments stopped on February of 2026. That's when the direct payments stopped coming to me.
And what is the total amount that he's given you in direct payments?
I cannot give you a total amount at this moment, but because it's been since 2023 when our divorce first began.
So Ms. Garcia is going to have a calculation of all the amounts that have not been paid, period. And then you need to testify as to the direct payments, and Mr. Garza needs to testify as to direct payments to see if there's a difference. I mean, you all know this more, nobody else does. So your numbers and talk to each other. It sounds like you can communicate. So So talk to each other about agreeing as to what amount was paid, and then I will compare that to what Ms. Garcia says. We will offset that and then see if anything's left over.
Now, I do want to let him, well, no, so he can know that the reason why he owes so much, right? Because like I said, there's two different cases. So they don't know about this case. They only know about the one you first opened. Well, I first opened, sorry, years ago, which was back in, I think, 2019, 2020. I can't even recall, to be honest. But that is the reason why there is arrears, because it has not been consolidated and the amounts have not been, yes, so clear.
I think you're right about
Yes,
that.
that's what it is,
Does
but
does that make
I don't
sense,
think that's-
Mr. Garza?
I'm just to update on as far as child support. I am behind the month of July
And August.
and up to this month. But as far as I'm concerned, those are 22 months I owe. Whatever the Attorney General has prior to that is being paid on full to her directly.
And that's something they need to fix. And I've tried to do it several times, Your Honor, but like I mentioned, they told me they have a whole system that's not working and
So, Ms. Garcia, I'm gonna call this case on September the 2nd. I suggest one of two things. Either we get this all ironed out and straightened out, or Ms. Gomez can testify about relinquishing any amounts and then the amount starting on a date certain, September the 2nd, for example, going forward. And that should hopefully clear up anything else. Does that make sense, Mr. Garza and Ms. Gomez?
yes, Your Honor.
So what I'm saying is either all of this gets straightened out and it's a ball of yarn that needs to get untangled in the next month. If none of that happens, just for your both ease of mind and so that your children continue to receive child support, you have the option of relinquishing any and all amounts, confirming that everything has been paid, and we start then. In other words, I'm wiping it all away at the
Okay.
next time if you testify that you've been paid everything,
Okay,
and we just start in September.
we can do that.
So come back. And that might be, let's see if we can get this right. If we can't, we'll just start over because you made all your payments.
Thank you, Your Honor.
All right. Ms. Gomez, Mr. Garza, you've been very patient. I appreciate you both.
Thank you so
Have a
much.
good day. Thank you for logging in, Ms. Garcia.
Oh, you're welcome, Judge.
Have a great day.
Next case, page number 1.
Brenda Ashley Gonzalez versus Jason David Rivera, cause number 2019 FLA 2258C3. Are you Jason David Rivera?
Yes, sir.
Welcome to court, Mr. Rivera. The court marks you present in person. Are you Brenda Ashley Gonzalez?
Yes, Your Honor.
Welcome to court, Ms. Gonzalez. The court marks you present in person. We're here for a final hearing and a petition to modify. Ms. Gonzalez, Mr. Rivera, what is the announcement?
We're here to modify the original divorce decree, which was joint custody. The contested issue is that I would like to move my 2 girls with me to Colorado. And I would like the court to see if it's in the best interest of the children to stay in Laredo or to move with me to Colorado.
And are you ready to go forward on your hearing?
Yes.
Are you ready to go forward, Mr. Rivera?
Yes, sir.
Who filed the petition to modify? All right, Ms. Gonzalez, Mr. Rivera, would you raise your right hands? Do each of you solemnly swear or affirm that the testimony you will give in this cause will be the truth, so help you God?
Yes, sir.
Yes, sir.
Both have answered yes. Ms. Gonzalez, bring yourself as close to the microphone as possible. Speak a little louder so that we can have a good record. Is your true and correct name Brenda Ashley Gonzalez?
Yes.
Ms. Gonzalez, how many children do you have with Mr. Rivera?
2.
Their ages?
2 girls, which 8 and 11.
All right, you've told me that their genders are female. You filed this petition to modify. What would you like the court to know? Or what would you like to tell the court?
I'd like the girls to move to Colorado with me.
Tell the court your story and why you believe that would be in their best interest.
Originally, we were supposed to all go to Colorado. Jason is originally from there. His father still lives there in Byers, Colorado. He was supposed to come when he graduated from his nurse practitioner school, which was, I believe, in 2022. At that time, he changed his mind. And the current order is no longer working if Jason wants to stay here in Laredo.
And tell the court, so your daughters currently live in Laredo.
Yes.
Tell the court why you believe it would be in their best interest to give you the exclusive right to designate the residents and move them to Colorado.
During discovery, I discovered a couple of things. Originally, I was going to allow them to stay here because they wanted to stay here. Their friends are here. And I understood that. During discovery, I found that Mr. Rivera is not tending to their general medical needs as he should, their vision needs, their dental needs, and their school grades. I know they're important, are not matching the standardized tests at the end of the year. Even though they are getting good grades, they're not. The standardized tests do not match that.
Are there any other reasons why you believe that you should designate the residents?
Not that I can think of.
Anything else that you want to tell the court?
No.
Somebody remind the court, did the court give an oath to both or just to Ms. Gonzalez?
To both.
All right. Is your true and correct name Jason David Rivera?
Yes, sir.
Mr. Rivera, you heard the testimony of Ms. Gonzalez. Ms. Gonzalez says that you have two daughters with her, an 8 and an 11-year-old. Is that true and correct?
Yes, sir.
You heard her testimony that she believes that it is in your daughter's best interest that Ms. Gonzalez designate their residence, and she's going to do that in Colorado if the court agrees that it is in their best interest. Do you agree or do you disagree with that request?
I disagree.
Tell the court why you disagree.
So, Your Honor, this is a case about the best interests of my daughters, Taylor and Peyton. The evidence will show that they have lived primarily with me in Laredo for several years in a stable, loving, and consistent home. They remained enrolled in school, attended regularly, performed well academically, received routine medical care and follow-up, maintained strong family and community ties in Texas, and continue to be healthy, safe, and thriving. The objective evidence before the court, including timeline, school records, attendance records, report cards, awards, medical records, demonstrate that their current environment has provided the stability and continuity that serve their best interests. For those reasons, I respectfully request the court to adopt the existing conservatorship and possession provisions, continue my exclusive right to designate the children's primary residence, order guideline child support, and enter a final order that preserves the stable environment in which my daughters have continued to thrive.
Concerned that you read all of that really quickly into the record and it may not be very clear.
So.
Go ahead.
Your Honor, this is a case about the best interests of my daughters, Taylor and Peyton. The evidence will show that they have lived primarily with me in Laredo for several years in a stable, loving, and consistent home. They've remained enrolled in school, attended regularly, performed well academically, received routine medical care and follow-up, maintained strong family and community ties in Texas. They continue to be healthy, safe, and thriving. The objective evidence before the court, including the timeline, school records, attendance records, report cards, awards, and medical records, demonstrate that their current environment has provided the stability and continuity that serves their best interests. For those reasons, I respectfully request that the court adopt the existing conservatorship and possession provisions, continue my exclusive right to designate the children's primary residence, order guideline child support, and enter a final order that preserves a stable environment in which my daughters have continued to thrive.
Mr. Rivera, in your own words, tell me, since Ms. Gonzalez has said and testified that it is your daughter's best interest that they live in Colorado because you have failed to attend to their medical and educational needs. Tell the court if that is true and correct, and if you disagree, tell the court why.
I disagree, sir. I've uploaded exhibits
that show my girls' grades, and they're outstanding grades. They're doing well academically. They have been doing well academically throughout their whole time of Blessed Sacrament. Their medical records are healthy. They have no issues. I'm sorry. They're generally well. My youngest daughter suffers from metabolic syndrome, which is, the beginning of insulin resistance, which we're working on. They get consistent awards. They don't really have any issues. They're happy and they thrive here.
You told the court earlier that they've lived with you for years. The court heard from Ms. Gonzalez that the original plan, and I don't know if it's true, but she's under oath, so I'll presume it is, unless you tell the court otherwise, that the original plan was that as a family you would move together. At some point you changed your mind. Did that happen or did that not happen?
No, that did not happen, sir. That when we divorced, when our divorce was final, there was no written agreement. There was no legal agreement that I would move to Colorado once I graduated.
Well, it sounds to me that you don't need a legal agreement to move. You make a decision, you tell the other person and they disagree or not. My question isn't whether there's a legal agreement. My question, I guess, is that it sounds that Ms. Gonzalez is saying there were just conversations as a family about moving, and at some point you did, and that's okay. You have the right to move or not to move. I'm not making a value judgment on that. I just need to find out what happened and factually what happened. And it sounds like Ms. Gonzalez is saying there were some conversations. There was just a meeting of the minds, an agreement about moving, and at some point you exercised your right and said, I'm not moving, and I just need to know if that is true or that is not true.
That is true, sir.
And when did that happen?
I was still in school, about to finish, and then it was my best, and I felt it was in the best interest of my children that we stay in Laredo.
One more time. When did that happen?
I was still in school, so I'm sorry.
Pretend like I don't know when you were in school.
Maybe like 2021, 2022.
So 2021, 2022. Ms. Gonzalez, does that timeline seem more or less correct?
I believe he graduated in 2022.
22.
Excuse me?
When did you graduate, Mr. Rivera?
May of 23.
So, Ms. Gonzalez, to crystallize for the court the timeline, when did you move and when did you realize, figure out, or were you told that Mr. Rivera was not going to move?
I moved to where Jason used to live in Denver, Colorado, in May of 2021. I found out that he was not going to come here, I believe in 2023 or 2022.
And during that time period for those 2 years, between those 2 years, between May 2021 and May 2023, where did your two daughters live?
Jason still.
And what was the understanding or the working agreement at that point? What was your impression?
My impression and something that I bothered Jason a lot about every couple months was that he was going to come to Denver to live because his father was sick. So he always intended to live there anyway. And for us to be together, of course, as a family.
And during those 2 years, did Mr. Rivera and your two daughters visit? Did you visit? What was the family arrangements at this time?
He came to visit, yes.
Was it once a year or periodically?
Periodically.
And how often did you see and visit with your daughters during these 2 years?
I would say around three times a year when he would come. He would come he would stay at his father's house. So he would come every holiday, I believe.
So Mr. Rivera would come and visit about 3 times a year with your daughters. Did you ever come down to visit them?
Not that I can remember, no. I might have, but I don't remember.
Yeah. And in 2023, when he told you or you realized that he wasn't moving and neither were your daughters, then what happened?
After he told me that he wasn't going to come here, I began to try to fly them in for every holiday, spring break, summer, Christmas, Thanksgiving.
And did that happen? Was that request well received? And did that happen?
It was not real well received, but it still happened on my dime.
Mm. Well, you heard that testimony, Mr. Rivera. Is there anything you disagree with?
So we'd adopted sort of an informal agreement, where the girls would go, the 4 breaks, spring break, Thanksgiving, winter break, summer break, and then they would spend the whole time over there. And that was working for a while, and then she would, at first we were splitting the cost of the flights, and then as the way she would handle the flights started becoming iffy. And then
What does that mean?
But they weren't consistent.
Mm.
They weren't consistent anymore. And
with regard to payment, with regard to times, with regard to airports?
Times.
Mm.
Times. And then there was several times where the kids were supposed to be back here and they weren't, for whatever reason. They missed a flight or whatever, and it caused significant delays. So that's where everything started to erode.
Well, you tell me what your impression is, because you use the word iffy and then you said there's missed times. Is it your impression that Ms. Gonzalez did these things by accident, on purpose? Was she neglectful, or is it just a scheduling issue that's easily explained some other way? What's your impression?
No, I honestly believe these were accidental.
So it's not iffy. It's just stuff happens sometimes, and
Exactly.
Especially when you're traveling with two children.
I'm sorry, intentional.
Okay, so that's why I wanted that point clarified. Iffy could mean that she's doing something inappropriate, but in this case, it means there's accidents that happen. I just needed to confirm that you're not making any allegations against Ms. Gonzalez. Ms. Gonzalez, flesh out for the court the medical and educational concerns you have. So I heard from you that there's concerns, and then I heard from Mr. Rivera the opposite, that some pre-diabetic condition is being I don't know if he said fixed or looked at or reviewed, and then he went on to tell the court that the girls, your daughters, are doing well academically. Flesh out for the court your position.
Should I do medical first? Or
As you wish.
um
Into the microphone.
oh. So Mr. Rivera claims that he does routine checkup on the girls, which doesn't look like it's true. I also uploaded my health record from my Blue Cross Blue Shield. They've had only a handful of evaluations over the last 5 years. Sometimes even skipping a year. Either way, I'm sorry, I'm getting nervous a little bit.
Take your time.
Either way, it seems like Mr. Rivera isn't tending to their health care as much as he should, even though he's a nurse practitioner. For example.
Objection, Your Honor. Improperly opinions call for legal conclusion and lacks foundation.
Overruled. You may continue.
For example, in November 2025, I had the girls for Thanksgiving, as I have been. I noticed that they had lice. I immediately told Mr. Rivera. I sent him pictures. He said he would take care of it. The next month, December, I had them for Christmas, December 2025. Now both girls have lice. One girl had lice the first time. Now both girls have lice. I immediately told him. I sent him pictures. He said he would take care of it. April 2026, I come here to see you. They have lice still. They still have lice. So this is 6 months, I believe. Yes, 6 months of lice. I told him, he said he would take care of it. The records show on my the health record, which is A346 through A365 for one of the girls. Exhibit 8, the A346. The record shows that he took them to the doctor on April 1st for lice. However, he did not get the medication dispensed until May 30th, according to the prescription records. So that's my example of he doesn't tend to them as he should, I believe.
And the concerns about about their education. Go ahead.
Oh, may I say something about the dental and vision?
Sure.
Okay, so dental, he has not taken them to the dentist for the entire time I've been gone. I established them in Colorado. So they've been going, they have their dentist there. I fixed Taylor's teeth, who she had a big old triangle in the front that she never got fixed. Taylor's cavity, Peyton's cavities got fixed. But prior to that, he just did not have a dentist for them. Their vision, the school records, they have been complaining since Taylor was in 1st grade that she needs glasses. They have been complaining since 2023 or 2024 that Peyton needs glasses. This was not taken care of until I noticed in June 2023, when Peyton began coming to my house. We got her glasses, I got her glasses, and then the next time that Taylor came, we got her glasses. But I didn't know the school was sending referrals, letting Jason know for years that they needed glasses. And he didn't either tell me, and he did not get it taken care of.
Anything else with regard to medical concerns?
No, sir, I don't think so.
Mr. Rivera, the testimony at this juncture is that your daughter's had lice for 6 months. Although it was seen by a medical professional, you did not fill the prescription that would have cured that. And on top of that, you failed to adhere to recommendations for other things, such as reading glasses. What response, if any, do you have?
Okay, 1 second, sir. So for the lice issue, Your Honor, head lice are a common childhood condition. According to the American Academy of Pediatrics, head lice are not associated with serious medical illness and can be difficult to eliminate because reinfestation and resistance to some over-the-counter treatments may occur. Your Honor, this is addressed in response to Exhibit Lice AAP. It also highlights there that they recommend non-toxic treatments. Okay. So the evidence will show the children were evaluated and treated. The condition was addressed appropriately. The children continued to receive routine medical care. There was no evidence of lasting harm or injury, and their oral medical records reflect consistent wellness care and follow-up.
Okay, so Ms. Gonzalez has alleged that your daughter's had lice and you did nothing to do that, to take care of that. And the only thing that you are doing is telling me a medical pediatric opinion that it's non-lethal. So unless you tell me that you did actively something to address that, I'm going to take that as true. And you did nothing for 6 months. I understand that reading medical reports and recommendations from a national association is good, but I'm more concerned about your actions versus national opinions. So tell me what, if anything, you did over the course of 6 months to address the lice issue. In other words, if you don't rebut this information, this court will believe it. Go ahead.
I have uploaded the medical records that show they were treated.
Tell the court.
So
what did you do, if anything?
So they were treated several times over the last few months, several times with OTC, over the counter, non-toxic ingredients, because once we get to prescription medicines, they're poisons. They're toxic. I uploaded onto
I just want to confirm, this is what I'm hearing. I'm hearing that they were evaluated by a medical professional, that medical professional gave them prescriptions that you decided not to use
No, no.
because they are poisons,
No, I did use them. No, I'm trying to explain the timeline.
even though they're poisons.
Wh-
What is a poison? And are you using the poison or not?
So they were treated, and then
I need you to explain the
the-
poison argument. Who prescribed them poison?
I did.
You did.
See, yes, because the OTC prescriptions were not, I mean, the OTC treatments were not working. And I tried several for months, and then even mechanical cleaning, it just wasn't working. And I wanted to avoid the exposure of spinosad or ivermectin, because these are for anti-parasites, but every medication has an effect on the body. I wanted to minimize that danger. When I noted, when I saw that these aren't working, we got to go to the prescription medicines. We went to the prescription medicines.
And which of those two would you describe as poisons? The over-the-counter stuff, or the over-the-counter medications, or the prescribed medications?
Prescribed medications.
And you think those are poison?
Yes.
And you use them?
Had to.
So are they poison? I mean, your testimony here is that you did what was necessary by giving your daughters poison. Not my words, I'm just regurgitating yours.
If so one of the exhibits I uploaded Thomson Reuters, it details the medications and the neurotoxins that they are.
But you gave it to them.
Had to.
So what is the complaint? I mean, I start to understand Ms. Gonzalez's point.
No. So she is alleging that I did not treat the children. And she's saying there was that lapse in care. They were not being treated, but they were treated. They were treated with over-the-counter medications that didn't work. And then
She's saying it took you 6 months to figure it out, and you're confirming that exact same point.
correct, but they were treated and there was no lasting harm.
I understand all points. Ms. Gonzalez, now tell the court, what is your concern? Crystallize and flesh out the concern regarding education. I heard a concern from you, and then I heard from Mr. Rivera that your daughters are excelling at school. Go ahead.
According to the school records, it may look like that. However, the end of the year standardized tests say different. Taylor is struggling with math, and Peyton is struggling with her word comprehension. According to we have it up into Thomson Reuters.
All right, so your testimony here is that your daughters are lagging behind in several subjects.
Yes. According to the end of the year tests.
And crystallize for the court, what daughter and what subject?
Taylor is lacking in math. Even though she's getting A's in math in class, she had I believe it was a 30 something in the standardized tests.
And any concerns with the other daughter?
Yes. I believe Peyton's word comprehension is at a 50. According to the standardized test. However, they are passing their classes very well.
Mr. Rivera, would you like to respond to this allegation that your daughters are falling behind on standardized tests?
Yes, sir. I deny that wholly. Their grades are outstanding. Their grades have been outstanding. I uploaded all the academic records showing their consistent grades. They consistently get A's and B's and have been since they started school. Standardized testings are not a indicator of how well a child is doing. The grades show they're doing very well. They're thriving and they have awards that I also uploaded that show academically they're great.
All right. Ms. Gonzalez, what else would you like the court to know, or what would you like to put on the record with regard to you being assigned the exclusive right to designate your daughter's residence?
May I say something about the education?
Say anything you want. Yes, ma'am.
Okay. Standardized tests are the only way that the schools can make sure the children are able to compute things and do things themselves, where classroom grades, they're getting help either from the teacher or at home. So that's my argument there.
All right. Anything else you would like to tell the court?
Yes, and I'd like to add one other thing, a medical thing that I noticed when the girls started coming to my house in 2023. Mr. Rivera allowed one of Peyton's earrings to grow into her ear. They're supposed to be taken out, cleaned. She lost one, and the other one, I guess they didn't want to take it out, according to him, because it was a diamond. But they hadn't taken it out for so long that it grew into her little ear. The plastic was embedded into her ear. So I had to cut it off with wire cutters and pull it out. And there's actually a picture of the big hole that it left in the exhibit, in one of the exhibits in A87. And that is the first indication that I got for the way Mr. Rivera doesn't tend to the medical needs as he should. The other things that I mentioned are just additional.
Sure. Anything else that you would like to tell the court for the exclusive right to designate the residence?
I feel the girls, since they're going through puberty so early, it is also in the best interest for them to come with me, since I'm their mother. I don't mean to be gendered, but they do need me. Taylor went into puberty when she was 10, and I believe Peyton will do the same.
Any response to that, Mr. Rivera?
Yes, sir. Your Honor, I disagree with the petitioner's characterization. The court has actual medical records. I respectfully ask the court to consider the objective records and the children's current condition rather than labels. Your Honor, this is addressing respondents exhibit petitioner's allegation compared to objective record exhibit medical neglect.
Tell me what that means in plain English. What are you trying to tell the court with that?
What I'm trying to say is they received care. They're getting care. They're healthy and they're thriving. Now, I want to address the hearing issue. So this happened years ago. Okay. There was no intentional neglect. That issue was addressed. There was no resulting harm to the children. I uploaded photos, exhibit image 243, 244, 246, 245 of the ears. Perfectly normal, perfectly healthy. They continue receiving routine medical care and wellnesses, and an isolated issue from years ago does not reflect overall care provided to the children. The other thing I wanted to say was there was a period where routine dental and vision screenings were not completed. I acknowledge that. However, the children continued to receive routine pediatric medical care, wellness visits, and treatment when they were ill. They remain healthy and successful in school, and there's no evidence that they suffer injury, untreated disease, or impairment because of the delay in preventive or dental vision screenings. One more thing. Since these last 2 years, 24 and 25, she had taken him to the dental and vision. Since from our temporary orders from them then, I was assuming she was going to take them for the summer and maybe continue that since we already established a vision and dental over there. That did not happen. So I did that. So we did already on June 5th, we established dental care here and vision here as well.
Does any other person want to be heard? Ms. Gonzalez?
Mr. Rivera continues to allude to just because nothing bad ended up happening means that nothing bad happened. Like, just because Peyton's ear didn't continue having that big hole doesn't mean, just because they don't have lice anymore, doesn't mean that everything that happened over the last 6 months can be negated. And that's not, I don't think it's, I don't know. Also, Mr. Rivera claims that since I didn't take them to dentist and vision this summer, that, you know, it's something that can be just, sorry, my words are not coming to my brain. I'm nervous.
Take your time.
Okay. I object to Mr. Rivera's statement. They do have things ready for them when they get to Colorado. They have their vision screening this month. They have their dental screening this month. Taylor is enrolled in mathnasium for her math. I've already paid, everything's in Thompson Reuters. Everything's ready for them to go. And I hope the court considers that.
Anything else from any person?
Yes. So, Your Honor, this is a case about the best interest of two children who have lived in a stable home, attended school consistently, maintained strong family ties and community ties, continue to receive appropriate medical care. I respectfully ask the court to base its decision on the objective evidence presented and to enter a final order that preserves the stability and continuity that have allowed Taylor and Peyton to thrive. Your Honor, petitioner has characterized my care as medical neglect. However, the objective evidence does not support the allegation. The medical records, school records, attendance records, academic performance, and children's overall health demonstrate that they have consistently received care, are healthy, stable, and doing well. While we may disagree about individual medical decisions, a disagreement does not establish neglect. I respectfully ask the court to rely on evidence and continue the stable environment that has served my daughter's best interests.
Does anybody else want to add anything to the record?
Mr. Rivera's make it seem like there's nobody in Colorado, and I'm going to be taking them away from their family. But all they have in Laredo is the grandma and his brother. In Colorado, we have the grandpa, which is Jason's father, and the girl's stepfather, Ashton. So they do have family in Colorado. I'm not taking them away, but I think it would be in the best interest for them to come with me.
Your Honor, if I could.
Sure.
In regards to family support, that is untrue. So maternal grandmother, maternal grandfather, paternal grandmother all live in Texas. Lyford was about 2 hours away. Her parents, her brothers, my daughter's cousins, they all live in Lyford. Here, my whole extended family lives in Laredo. My father is the only one non-related to Brenda that lives over there, and they don't communicate. And my father will be moving down here because he's already an older man. So we have strong family support ties here in Laredo for the children. If they go to Colorado, I do not believe it's in the best interest because it's Brenda and her new husband.
Finish that thought. What are you trying to say?
I'm trying to say is we have stable, strong family ties here in Laredo, in Texas, and we're moving them away from strong stability to just Brenda and her husband.
All right, Ms. Gonzalez, Mr. Rivera, anything else you want to put on the record?
My family is 2 hours and 45 minutes away from Laredo, and a plane ride is 2 hours. So I don't see Mr. Rivera's point, I guess.
Sure. All right, folks, I'm going to make a decision.
One last thing. The children have stability here. They've established routines, are doing well in school. They have family support, are thriving in this environment. I respectfully ask the court to continue the arrangement that is working in their best interest. The only thing I wanted to add, Your Honor, my final proposed order, if there could be a small change and I believe it's a significant concession. I had adopted a previous version of her travel stipulations, and I wanted to change that to reflect our previous what is it called? Our previous agreements, where the girls would go all of spring break, all of summer, all of Thanksgiving, and all of winter break. They would go all 4 breaks every year. Okay. And then plus the 1 week that she asked for. Because right now it's 1 year her, 1 year me, 1 year her, 1 year me. I don't believe that's in the best interest. It takes time away from them to have meaningful relationships with their mother. That's not in the best interest.
Well, let me ask you this, Mr. Gonzalez, on that
Yeah.
concession. Excuse me, Mr. Rivera, on that concession. This is a lot of travel. Under your proposal, who's going to pay for all that?
So I also adopted the same language that we had done in our temporary orders. So those travels were going to go 50-50. And then the extra week, she was going to pay by herself, but I am asking the court, we will do 50-50 as well. That's the travel portion. And then since I'm asking for guideline support, and I understand there's now significant burden, I asked the court that the medical insurance portion that she pays, we go 50-50. And any
Let me ask you this: if the shoe were on the other foot, and I don't know the answer, and that's why I'm asking Mr. Rivera, if the court, if capital I, capital F, hypothetical, if the court orders that your daughters go to Colorado, do you think it would be fair, right, and just that you pay for 50% of the travel to come to Laredo?
Yeah, yes.
All right. Continue your last thought.
Since I understand that it's a significant burden to have this new child support, out-of-pocket medical expenses that are made by me, I will pay them. So like we got glasses, it's $180 out of pocket. I would pay the whole thing and not add that additional burden onto Brenda.
Anything else to put on the record?
Yes. I feel if the girls do stay here, Mr. Rivera will continue lying to me about their medical needs. For example, when I first got Peyton her glasses in June 2024, which is in the receipts are in the exhibits. I texted him immediately and told him that, hey, this is your half, this is what I paid. He immediately said that for me to return them, and the school has not complained, so why are you getting these glasses? And I believed him at the time, but I still got them glasses.
Objection, Your Honor, hearsay.
Overruled. Go ahead.
However, when I did discovery, I found out that the school had been sending referrals for years. And they had even sent one 4 months prior to me getting their glasses. That was the last referral in 2024 that they got. To this day, Your Honor, I don't believe Taylor is wearing any glasses. She lost the ones that I bought her last year in December, and Mr. Rivera has not replaced them. So she is completely, her vision is very bad, so she's completely blind. He also objects to he calls it he says they're not responsible enough for glasses, and I object to that because you're supposed to teach the kids how to wear them, how to take care of them. It's not something that you can just say, oh, they're not responsible enough. There's so much, Your Honor, and I'm so sorry that I'm rambling, but there's a lot. And thank you for listening.
I think this case is important, and this case reminds me of why these cases are so important and so difficult, because you have two very important daughters, very special daughters that and everybody wants what's in their best interest, and I need to make a decision. So I'm going to do that, but in part, and then I'm going to give you each some homework because this part nobody has really fleshed out. But here, the one central issue before the court is the designation of these children's residence. I'm going to take as true everything that Ms. Gonzalez said, and I'm going to take as true everything that Mr. Rivera has said, and there really is only one outcome. I mean, there can be no other outcome in this situation. And these are the things that the court looks at to arrive at this decision. Ms. Gonzalez moved to another state. What the court has gathered from that is that was a good reason, and she didn't run away. She didn't leave for bad reasons. She left for a good, right, and just reason in 2021, and then realized in 2023 that Mr. Rivera was not going to follow. In that interim, it sounds like the visits were ongoing but sporadic. And during that time, it sounds like to the court, and I think the evidence and testimony is not in dispute, that the daughters established stability and developed a routine with Mr. Rivera as their primary caregiver for those 2 years. Subsequent to that, Ms. Gonzalez, I guess, legally called him out and said, you were supposed to move and you girls need to be with me. So what the court looks at is the testimony provided by Ms. Gonzalez. She has specifically noted 2 things, education and medical concerns, and the court needs to make a decision as to what is in the girl's best interest and if there has been any significant difference and what their well-being is. With regard to their education, the court has heard from Ms. Gonzalez that they are lagging behind as reflected in standardized tests. But she has also testified, and it's uncontroverted, I believe she said that they are passing very well. So it depends on what metric you look at, right? If you look at standardized tests, they're not doing that great. But if you look at their actual academics, they're thriving. So I think that point is not in dispute. And without knowing any information, the court can only presume that they are doing well academically, but they probably don't do that well on standardized tests. But academically, it's undisputed that they're doing well. So the court moves on to the next issue, and that is the medical concerns. And I think the one that gave the court the most pause was the unresolved scalp or lice issue for 6 months. Now, I understand Ms. Gonzalez completely, and I even understand completely her perspective. From her perspective, if there is a diagnosis and there is a solution, then the solution is applied until the remedy is achieved. In Mr. Rivera's position, he says, well, yes, but I have the right to try things out. As a parent, as a dad, or as any parent, mom or dad, I have the right to try it out. And so long as it's a non-lethal diagnosis that I put my child in jeopardy, I have the right as a parent to try things out. I'm not saying I agree with that. I'm saying the law definitively does agree with that. Parents are allowed to try things out and get things wrong sometimes, so long as the child isn't put in harm's way. And I don't think that this situation calls for finding that they were ever in harm's way. As a parent, he made a series of not the best decisions that ultimately led him to the original remedy, and that resolved the entire situation. But I can't fault him legally for that. As a parent, I think a lot of people would reach a different conclusion, but and I understand that, and I fault nobody for that. So the court finding that the 2 daughters, the 2 children in this case have been provided stability, and the court recognizing that the court, and I understand and I appreciate the argument made by Ms. Gonzalez about gender perhaps being a factor. This court cannot assign a value to benefit one gender or the other. So all genders being equal, the court still arrives at the same conclusion. Since they have stability, they are thriving in school, and there are no medical issues of grave concern in this case, the court finds that it is in their best interest that Mr. Rivera continue to be designated the conservator that can designate their residence. That being the case, those are the orders of the court. Those are the findings of the court. Here's the homework that the court is going to assign to both Ms. Gonzalez and Mr. Rivera. I need you all to talk because over the next few weeks, because what I'm not convinced with is the original court orders or the temporary orders that assigns a heavier burden to Ms. Gonzalez for travel, knowing that there is now a concession that the girls will travel all 4 breaks plus a week. I need you all to talk to each other and be reasonable about what you all can agree to with regard to those travel expenses. I want you to talk about airports, flights, routes, driving, whatever you want, because you all know your airports, you all know your roads, you all know your travel destinations. I don't, but I need you all to talk to each other about that, because you need to think about not only your finances, but you need to think about these girls. Is it better to fly out of Laredo, San Antonio, Houston? I don't know that answer, but I think if each of you did some homework and then come back to the court and say, Judge, the best thing for the girls is that they leave on a Thursday at 5 from Laredo or a Saturday at 8 a.m. from San Antonio. I don't know. And then see what flight carriers, what airlines fly in and out of those airports, what flights are reasonable, what the average cost is, how you think this court should order the disposition of those flights, who should be reimbursing who should be making those travel arrangements, and so forth.
Judge, may
Mr. Rivera.
the temporary orders that we had, they had addressed most of those issues.
And do you disagree with any of those?
Just except for the changes that I had mentioned earlier about, about giving them more time and splitting the extra week 50-50. That those orders were good. I just wanted to have more
So
time.
then Ms. Gonzalez, giving you more time as conceded and agreed to by Mr. Rivera, do you agree or do you disagree with the temporary orders with regard to travel costs?
Agree. I agree. They're 50-50, right?
Yes.
I believe, yeah.
Yeah. And Ms. Gonzalez, do you agree or do you disagree with the calculation of child support?
I disagree.
Tell the court the basis of the disagreement.
If you look at the exhibits of the plane tickets, if I'm gonna have them once a month, and then also the holidays, each girl is about $600 round trip. It's not feasible for me to pay child support and have them come see me, because it's just not affordable. It's not. And I didn't choose for them to stay here in Laredo, and I can't come back. So
I don't disagree with any of that.
and also I know I'm gonna be still picking up the medical issues that I'm still gonna be doing the vision. I'm still gonna be doing the dental. Sorry. I know you said that there was no lasting harm for the medical stuff, but if Taylor had been treated in first grade the way she was supposed to be, her vision wouldn't have degraded into what it is now. And I feel like I'm still going to be picking up the slack, like I should, right? But there shouldn't be there should only be 50% slack that I should be picking up, not 100%.
Sure.
So is what I'm trying to say.
Well, you heard that request, Mr. Rivera. Do you agree or do you disagree with the travel costs?
No, with the travel costs, I agree.
So you agree to this offset since she's going to have more time.
Correct. She'll have more time. We split trouble 50-50.
She's requesting an offset, if I understand her correctly, to offset the travel plus the additional time.
But can you explain offset?
So like not credit, but so she's since there's travel costs associated with getting the girls to Colorado plus their stay for extended periods of time. I think she's requesting a reduction in child support to help with the cost of travel.
Including the 50-50. Because we're gonna split travel costs 50-50 like our temporary orders.
I'm reading between the lines. And what I'm hearing is in order to make my child support payment plus pay for travel costs, because all you have to, you have the responsibility of designating the residence. So you provide housing, but you don't provide child support. All you're going to put into this equation is travel costs. She's saying, I'm putting in travel cost and child support. Please take down the child support to help me pay for the travel. And I want you to respond.
I agree.
All right.
That is in the best interest.
So tell the court what the agreement is in the reduction. What is the current amount of child support ordered?
1,000.
And what is the agreement, Mr. Rivera, to a reduction to what amount?
Well, guideline supports, it's around 2,000.
That's not a reduction.
No, I know. I'm just mentioning the guideline supports 2,000 and the current temporaries are 1,000.
Right. I don't disagree with any of that. I'm just saying you agreed to some reduction to help Ms. Gonzalez offset some of the travel costs. My question is, what is it that you two can agree to in that reduction?
So if guideline is not supported, the temporary order is 1,000.
So you don't agree to a reduction? I'm just using your words. I'm not trying to fish for any differences. I'm hearing one thing.
Okay, I understand. So no, from the temporary orders, no, I disagree. If guideline support was ordered, then yes, it moved back to the regular $1,000.
Response, Ms. Gonzalez?
I'm going to be paying Mr. Rivera $1,000 plus another $500 for my half of getting the girls to and from Colorado per month. So I don't see it's fair or just that I'm still paying this money when Mr. Rivera has no real bills. I pay all my bills. So it's
What do you mean he doesn't have bills?
he doesn't have a house payment. He doesn't pay for insurance. I do. He doesn't pay for dental, vision, health insurance. I pay all of that, and I've been paying all of that. He doesn't have any real bills.
Anything else for any person on the record? All right, the court finds that the court is going to adopt the findings of the court that it is in their best interest that Mr. Rivera continue to designate the primary residence of the two girls. Nothing changes other than two things: that the agreement between the parties that the 4 major holidays will be spent with Ms. Gonzalez, plus an additional 1 week at her election. The court, in the best interest of these children, and what I'm trying to do is I'm trying to maximize all of the available resources to these daughters, to these 2 girls. The court is going to order child support in the amount of $800 per month beginning August 1st, 2026. These are the orders of the court. Oh, and the person that doesn't have possession of the girls is granted video conferencing capabilities with them every day at 7 or 10 minutes thereafter if they're not available at 7. Any objections to any of these orders, Ms. Gonzalez?
Yes, I thought you said we were going to be able to talk about it amongst ourselves, try to agree on something.
You can do that, and you can present your agreement to the court at the next hearing. If you don't agree, those are the orders.
I don't agree with the $800.
He wants more than 1,000.
I know, yeah.
So, I mean, if you want me to look at guideline orders, I can. I mean, if you want me to reconsider, the only option I have is to look at your W-2s and order 25% of your net. And I don't know what that is. I'm just saying, I think in this situation, I think that that would be in the best interest of your daughters. Why don't you talk amongst yourselves and then come back when the orders are due on?
Would this be on a pro se docket, Your Honor, or by submission?
Give me the pro se docket.
September 2nd at 2 p.m.
Any person that doesn't have possession of the girls will have video conference capabilities at 7 p.m. These are the orders of the court due to the court before September the 2nd at 2. If you have a different agreement, happy to hear it, happy to consider it, and happy to approve it if it is in your daughter's best interest. Not stick to these orders. Mr. Rivera, do you have any questions for the court?
No, Your Honor.
Ms. Gonzalez, do you have any questions?
I do.
Mr. Rivera.
I do, I'm sorry. Just so I know the court stance. Brenda wants 0 child support.
No.
That's okay.
Brenda wants something less than 1,000.
No.
Miss
But
Gonzalez wants something less than 1,000.
her original,
He
What's the objection?
is talking about our negotiations that have happened over the last several months, me trying to. And
So don't tell the court what you all talk about outside, but you can make an argument, Mr. Rivera.
So she wanted the 50-50 travel and wanted 0 child support. Because she says it's financial burden.
Sure.
But I don't believe that's in the best interest because the girls need money. So it's not in the best interest to put 0.
I absolutely wholeheartedly agree with that.
And I believe 800 is fair. It offsets the travel and it allows support.
Anything else, Ms. Gonzalez? Yes, ma'am.
it is true. I feel it's true and correct that that is the girl's money. And I have to bring up that if it's very important to Jason now, but it was not important to Jason in 2020 when he was ordered to pay only $50 a month for child support, which he never even started. And I feel like it's an undue burden to me. When I had compassion for him, I only had him pay $50 a month, but he has none for me right now. And
I'm with you that I wish things were different in the past. I can't change, fix, modify, or go back and change any of that. The only thing that I can do now is order things that are in your girl's best interest. And please do not ever believe, and I tell this to all folks that are ordered to pay child support, don't ever believe that a single dollar should benefit or belongs to Mr. Rivera. Every single dollar that's ordered is for the benefit, use, and enjoyment of your daughters.
which they never got.
Your child support?
Yes.
No, I can't. I have no evidence.
It's actually in the evidence. I uploaded a.
What does that mean they never got? As long as they hit his bank account, they got it. So I'm going to tell you exactly what I tell people same thing that I tell people that are ordered to pay child support. They don't have a right to say you need to use this money for shoes, for clothing, for electricity, for books, or for anything. Parent that receives child support can use it for their use, benefit, and enjoyment.
Oh, no, sir, that's not what I meant. I'm sorry. I meant that I uploaded a ledger from the child custody attorney general that says he never paid anything between 2020 and now. So I just wanted to bring that up.
Was he ordered to pay child support?
He was ordered to pay child support. Like I said, $50 a month. I uploaded the ledger. I uploaded the motion for you to calculate how much he would have owed.
Do you have a motion to enforce that?
Motion to enforce what?
The child support owed to you?
Like.
But I can't do anything with that unless you make a request to the court saying I want a credit for the amount that he owes me and I want it offset with the amount that I owe him.
I believe I uploaded one to E-File, Texas.
A request for,
I forgot the name of it.
so, okay.
Yes.
So come back on September the 2nd and tell the court if you have a different agreement to tell the court what amounts, if any, you want credit for. But I think that's the court point, to reiterate the court's decision. If there was 2 years of not coming to court and saying, Mr. Rivera's decision is wrong to stay, to not have my girls with me in Colorado, and that didn't happen for 2 years. The exact same thing the court is hearing about child support that isn't due to you, but it was due to your daughters at the time that he owed it. And if you didn't come to court to request a change or modification or enforcement of that, then you kind of sort of lose the right to complain years later. All right, folks, I wish you all the best. You're welcome to participate in person as always, or by video conference at the next hearing, where I will sign the orders that you all provide to the court on September the 2nd at 2 p.m. Mr. Rivera, do you have any questions for the court?
No, sir.
Ms. Gonzalez, do you have any questions?
No.
I wish you both well. More importantly, I wish your daughters all the best. Ms. Flores.
Would this be an in-person hearing, Your Honor?
I just said that it is by video conference if they choose to participate as such. Up to you. All right. I wish you both very well. Ms. Flores, are any court will call the rest of the cases as the cases appear on the docket. Page 2, case 5, Kimberly Benavides, Leopoldo Benavides, cause number 2026 FLA 776C3. Kimberly Benavides, Leopoldo Benavides, are you present? Did Ms. Benavides receive notice of this hearing?
I'm looking into it, Your Honor.
The trial on merits was mailed to her, but we did receive it back, unable to forward, but she was emailed the notice of sending.
Let us start, John.
Give me one more setting.
October 14th at 2 p.m.
Page 4, case 9, Stephanie Robles versus Francisco Garcia Juarez, cause number 2026 FLB 498C3. Stephanie Robles, Francisco Juarez, are you present? This is a second trial on merits. This case is dismissed for warrant of prosecution. Court will prepare its own orders. Ms. Flores, have all cases been called on today's docket?
Yes, Your Honor, all cases have been called.
This now concludes this docket held in person and by video conference for Wednesday, August 5th, 2026. The court continues to embrace the latest technology to provide safe and uninterrupted access to justice without delay. Today's docket was made possible by the appearance of counsel and parties and by the assistance, diligence, and preparation of the Webb County Court at Law 2 staff and the employees of Webb County that provide judicial support to the court, the Sheriff's Office, and both of our clerk's office, the Webb County Clerk's Office and the District Clerk's Office. The court thanks you all for your service. Have a good day.